Kalina,
Should I start? Okay.
1, 2,
3. Welcome everyone to this ETUI workshop on exploring interfaces between labor and environmental law. And just to briefly introduce myself, my name is Kalina Arabagieva, and I'm a researcher here at the ETUI. And I'll also moderate this first panel on the intersections between labor and environmental law in the just transition and sustainable development context. And perhaps before I start speaking, I would just like to flag the fact that you can listen to this in both English and French. And if you'd like to switch on interpretation, it's at the bar on the bottom of your screen on the very right. It's a little globe which says interpretation. So you can listen to it in either English or French. So just again, welcome to everyone. Just a short introduction to the workshop. Now, labor and environmental law are two fields of law and scholarship that have rarely directly engaged with each other, having emerged as distinct legal fields at different times, originating from different social movements, and which relate to distinct bodies of law, each with its own goals, discourses, and actors. And if anything, they have at times been perceived as being in conflict with each other, as environmental regulation has been cast as a limitation on economic growth, and economic growth has been cast as a source of employment, the so-called jobs versus environment dilemma. And so the aim of this workshop is to explore such at least apparent tensions and to ask if and how they may be resolved, but also to go further than this and to start thinking about some common problems and shared interests and goals, and also spaces for productive synergies between these fields. And I should say here that the interfaces we might want to explore today are not just between labor and environmental law, but also climate law and environmental justice and climate justice. And I'm very happy to welcome here today colleagues working in labor law, as well as environmental law and climate law to help us start this conversation. And I'm also very happy to say that over 500 people registered for the workshop, which I think means that this conversation is timely and also interesting and important. And so why are we having this conversation now? In my view, it is because concepts such as just transition, but also sustainable development, which have gained prominence at the international and national policy level, bring together and also seek to reconcile environmental and social concerns also relating to workers. And we can see the integration of these concerns also in the relevant instruments, such as the ILO guidelines for just transition, the Paris Agreement, and the European Green Deal. And these concepts themselves, as well as the accompanying policy framework, open up space to explore the intersections between labor and environmental law. And it is clear by now, I think, that the social and economic transformations that will be required to respond to climate change will have profound implications for labor markets and also for workers. And it is also clear that this transformation, to be successful, must address the concerns of workers, and it must also ensure that the benefits and burdens of this transition are distributed in a fair way. And I think that environmental, climate, and labor law have a crucial role to play in this process. And this is why the first panel today looks specifically at the context of just transitions and also, to a certain extent, sustainable development. And in this panel, we will look for common ground or a common narrative that might suggest some convergence in goals and interests between labor and environmental law, and therefore also scholars from both fields. And in the second panel today, we'll look at these questions from different perspectives, offering different examples of channels of communication or avenues to explore the nexus between labor and environmental law, also beyond the just transition context. So we will hear, for example, about the possible interfaces between labor and environmental law in occupational health and safety, or about the role of collective worker voice in promoting environmental sustainability. And the second panel will be structured around a presentation by an expert in labor law and followed by comments by a colleague working in the sphere of environmental law. And so I'm very much looking forward to all of the interventions today, and we will have time for questions and discussions in both panels, of course. And so now I would like to turn to introducing the speakers in our first panel today. Our first speaker today, I'm very pleased to welcome David Dory, who is an associate professor of work law at York University in Toronto, where it is apparently very early in the morning. And he's also a visiting research fellow at Harvard Law School. David researches in the field of labor law and industrial relations, legal theory, corporate social responsibility, and labor and the environment. And he has published a number of papers on the intersections of labor and environmental law in the just transition context. And today he will present on the contested boundaries of just transition law. Hi, David. And then our second speaker today is Navraj Singh Gali, who is a senior lecturer in climate law at the University of Edinburgh. And his research and teaching address legal responses to climate change with a focus on public and constitutional law. And he has written also on the potential for more engaged relationships between labor and environmental law, and also social democratic thought and climate law. And today he will speak about mainstreaming just transitions, risks, rewards, and application to the North Sea. And our third speaker today will be Sanja Bogojevic, who is an associate professor of law at Lady Margaret Hall and the University of Oxford, researching in environmental and EU law. And her work focuses on the interlinks between public and private spheres of these areas of law, including the role of markets in environmental law, the greening of procurement law, environmental rights and climate change litigation, but also the interlinks between populism and environmental law. And the title of her presentation will be Labor and Environmental Law, an Antidote to Populism. And I think Sanja is potentially not yet with us, but I hope that she will join later. And I very much look forward to hearing all three presentations. For the speakers, you will have 15 minutes for your presentations. And I will remind you when you have 5, 1, and 0 minutes left. And also here with us today are two excellent discussants. Paolo Tomasetti is a researcher in the field of labor law and industrial relations at the University of Bergamo. He has a number of publications on the topic of labor law and also environmental sustainability and the role of collective bargaining and social dialogue in the just transition and sustainable development. And he also has a book on labor law and the environment in Italian, Diritto del lavoro e ambiente. And our second discussant today is Loveleen Boulard, who is a lecturer at Birmingham Law School. She researches in the sphere of international domestic environmental law and policy, climate change, environmental constitutionalism at the international level and in India. And she has written also on sanitation and water in India and climate change issues in Southeast Asia. So welcome also to Paolo and Loveleen. Thank you very much for being here. You'll have, the discussants will have 5 minutes after the presentations, and I'll remind when you have 1 minute. And a warm welcome also to the audience again. If you have any questions for the speakers or discussants, please post them in the Q&A, and we will be able to see them and ask them after the interventions. And if you have any other questions or any other issues or technical problems, please post in the chat. And I see that Sanja is here today, so welcome, Sanja. I'm very happy to see all of you. Okay, so that's it from me. So I'll turn now to our first speaker, David. The floor is yours.
Okay, let me just share the screen here. Did that work? Okay, so first of all, I want to thank the ETUI and Kalina for inviting me to this. I want to start with a short explanation of how I came to be talking about just transitions and the law, and to give some in order to give some context to my approach to the subject. By training, I'm a labor lawyer. Before returning to academia, I was general counsel to the United Steelworkers in Canada. So I know quite a lot about labor law, but I hadn't given much thought to climate change as a legal problem. From a legal perspective, climate change was primarily a challenge for environmental law, not labor law. And then about 7 years ago, I was asked to be a token lawyer on a big research project funded by the Canadian government called Work in a Warming World. That was hosted at my university and by a lead researcher named Carla Lipsick-Mumé. And the idea of the project was to examine how climate change will impact Canadian labor markets. And I was asked by Carla to write a paper about labor law and climate change, which sounded really interesting. But when I actually sat down to think about what to write about, I was stumped. because really, what does labor law have to say about climate change? Well, I looked at the legal literature, and let me just get my PowerPoint. There we go. I looked at the legal literature, and there was very little written by labor lawyers about climate change at that time. There was quite a lot written by environmental lawyers and energy lawyers, some of whom were arguing for the creation of new legal fields with names like climate change law. Their argument was the challenge of climate change was too complex and multifaceted and cross-disciplinary to be dealt with within the boundaries of environmental law alone. So climate change law would draw in a variety of other legal fields, such as energy law, land use planning, tax law, among other legal fields, to build a more holistic legal model to deal with the huge challenge of climate change. But these environmental law and climate change scholars rarely, if ever, mentioned labor law as a relevant field in their grand project. Labor markets were the subject of labor law, not environmental law and climate change law. So when I started looking at the interaction of labor law and climate change law about 7 or 8 years ago, I found that environmental law and energy lawyers were thinking about law's role in constructing a transition away from fossil fuel. But labor law was not on their agenda. And labor lawyers were barely thinking about climate change at all. Now, I did find quite a lot of writing by unions and international organizations like the ILO and UNEP. And as this audience will know, that work developed a concept called just transition. And the early just transition writing had a relatively narrow focus on protecting fossil fuel workers who may lose their job in the transition towards a lower carbon economy. And just transition described a set of policies that were designed to cushion the blow for fossil fuel workers and their communities as government policy phased out those industries. A just transition called for a fund to provide various benefits and services to displaced workers and affected communities. Now, in that just transition literature, I found a lot that was familiar to labor law because the focus was narrowly placed on the ramifications of closing down coal mines and helping coal miners transition to new lives. So many of the just transition policies involve subject matter that could be considered to fall within the general realm of labor law. So there were, calls for retraining and apprenticeship programs for displaced workers, changes to pension laws to bridge people who would be retiring early as the coal mines closed, changes to unemployment insurance programs to ensure workers have extended access during the transition phase. Some just transition proposals called for displaced fossil fuel workers to be given first opportunities at new clean energy workplaces, which presumably would require some sort of law of hiring that would ensure they get first preference. Collective bargaining laws would be relevant insofar as unions and employers were attempting to bargain collective agreement clauses that related to climate change. So there was certainly space for labor law within the emerging just transitions policy literature, even if very few labor lawyers were engaging with that literature. It was mostly unions seeing the writing on the wall and proposing benefits to protect their members as the fossil fuel jobs were phased out. So for the contribution that I was asked to make for Work in a Warming World, I published a paper a few years back called Just Transitions Law, Putting Labor Law to Work on Climate Change. And this was mostly a thought exercise that attempted to map out what a legal field called just transitions law would entail. What is the content of a law of just transitions? And if we were to this is one of the ways I thought about this, if we were to write a textbook to be used in a new class called Just Transitions Law, what would be in the book? What would the chapters cover? Well, if that book were based on the original concept of just transitions, then the table of contents might look something like this. This is just a quick snapshot. It's no doubt incomplete, but it's enough for now. Focus would be on the labor market effects of displaced workers from high carbon industries and communities caused by the transition to a lower carbon economy.
Sorry, David. Sorry
Yep.
I'm very sorry to intervene, but is there any chance you could make the screen slightly bigger, because I think some people can't see it very well?
I really have no idea how to make that.
Okay.
bigger.
Well, anyway, the slides. Perfect. I think that's way better.
No,
Thank you.
but that's the next slide. So this one, I don't know. I'm happy to send you.
It's
Did
already
that
better
work?
now. Yeah, that's
Oh,
better
okay.
now. Yeah, thank
All
you.
I have
Thank
to do
you
is
so
make
much.
it bigger on my screen. I just learned something new there. Okay. So the focus, so the focus would be on transitioning out of a transitioning to a lower carbon economy. And so part of our just transition law textbook would focus on the law of economic transitions and how we can use law to cause and manage a transition, energy transition. And so this is where we would find chapters on environmental law and energy law. But also, I thought there would be chapters on tax law, indigenous law, property law, and probably a whole bunch of other areas I haven't listed here. For example, constitutional law in some countries would have to be engaged. And so the idea is that a variety of legal fields would be engaged in the process of transitioning from a high to a lower carbon economy, and just transitions law would engage those different areas of the law. But even from this very quick snapshot, we can see the complexity of the project of designing a legal field called just transitions law. The multidisciplinary cross-sectional nature of the challenge of transitioning economies makes it immensely complicated from a legal taxonomy perspective, because few people or government departments have the expertise in all of the areas that are engaged. Our textbook would then have to shift to the justice part of the just transitions equation. The justice part, in the narrow original sense of just transitions, emphasize the plight of workers who lose their jobs. A just transition in this sense is one in which displaced workers are looked after and their communities are given resources to reinvent themselves so they don't turn into ghost towns. And this part of the book would, again, be more familiar to labor lawyers. It would focus on various areas of the law that would be engaged in order to provide workers in high carbon industries to provide benefits to the people who are being phased out, right? So we would, again, as I mentioned earlier, we would have chapters on unemployment insurance law, pension law, training and apprenticeship law, collective bargaining law, some labor standards to deal with hiring issues and so forth. Now, the point I'm making here is that if just transition law relates to the questions about how law would manage a transition to a lower carbon economy and on providing displaced workers and their communities with benefits, then labor law has a very particular and narrow role to play in the story alongside environmental law, energy law, and various other legal fields. But now we need to shift gears, because in fact, just transitions has since moved well beyond this original narrow meaning the labor movement ascribed to it. Just transition law has been co-opted by a wide range of academic disciplines, governments, organizations. Today, it's frequently used to describe a fundamental rethinking of capitalism, politics, and the market system as a whole. So I'll call this the broader vision for just transitions. I've just put a few quotes up there that capture this broader vision, but you can see from the language used that this version of just transition is talking about a restructuring of society globally. And so what happens here is this broader version of just transition fundamentally shifts the boundaries and scopes of law's domain in the field. Or to put it more practically, my just transitions law textbook just got a whole lot thicker. Right? The broader version of just transition is no longer focused on justice to workers per se, making use of the opportunity presented by the need and political will to transition to a cleaner economy. Just transitions is now a catchphrase to encompass a broad, grand vision for a 21st century reboot of global society, politics, and capitalism. Now, one potential irony of this vast expansion of just transition is that there's a danger of the term becoming uselessly broad. The goal of just transitions law is to correct every conceivable injustice in the world, past, present, and future, economic, political, and environmental. Then it's not a very useful organizing concept. At least it's not very useful for organizing legal materials and legal strategies. And that's why some scholars are calling for a return to the original idea of just transition. So Anne Eisenberg, for example, at the University of South Carolina, has written an interesting piece where she argues that just transition should be understood as just part of the sustainable development triangle that balances equity, the economy, and the environment. And so just as environmental justice reminds decision makers to consider the effects of environmental decisions on disadvantaged communities and minority groups, just transitions reminds decisions to consider the impacts of a transition to a lower economy on workers and communities that are most directly affected. But I actually think the horse has already left the stable, that the broader version of just transitions now dominates the discourse. And in addition to vastly expanding fields of law that are potentially engaged in this broader vision, the broader concept of just transitions involves a very different understanding of justice than that which was intended by the original labor movement, people who coined the phrase. And so I'll wrap up here because I know I'm low on time. The original narrow concept of just transition, not surprisingly, had a quite narrow understanding of justice. A just transition, as I noted, was one that took care of workers and communities who will be displaced because of the transition. You can see an example from my country here of a government task force on just transition that applied the narrow view of it, of just transition, right? Clearly the focus here was on coming up with policies that will help displace coal miners. But the broader vision of just transition involves a whole range of complex, overlapping, and sometimes conflicting views of justice. Here's a quick and dirty summary of the various justice stories that would form a normative agenda or framework that needs to be guide a broad understanding of just transitions law. I say quick and dirty because obviously there's an oversimplification here. There's different versions of each of these stories of justice. But all of these justice narratives are valid and compelling. Just transitions in the broad sense will need to develop some way to reconcile them, particularly when their prescriptions conflict. So, to give one obvious example that this audience will know, proponents of the narrow version of just transition have argued that laid off coal miners should be given preferential access to publicly funded training programs and to new clean energy jobs that might become available. And that makes perfect sense within the logic of the narrow understanding of justice that focuses on displaced fossil fuel workers in their communities. But from the perspective of environmental justice and climate justice and intergenerational justice and restorative justice, the idea that formerly well-paid, privileged, mostly white male coal miners should again be prioritized in access to good jobs is an obvious point of contestation. We may be able to come up with a theory of justice that effectively merges these various justice narratives into a coherent meta-level theory, a just transitions justice, if you will. But right now, there's still a lot of writers and thinkers working away on these questions. And as I said in my original Just Transitions paper, they are doing so in their own disciplinary silos, rarely speaking to one another. And now there's been some, in recent years, more attempts to break down these silos and engage in cross-disciplinary dialogue, but there's a long way to go. And there's a chance that my field, labor law, is being left behind as just transition takes on a much broader meaning in a worldwide dialogue about the future of the world. And I'll stop there. Thanks.
Thank you. Thank you very much, David. And also just to keep into time, I'm actually not sure, could you see me putting up the...
I saw the last one, yeah.
Okay, fine.
Yeah.
So everybody else can see me as well. Okay, thank you. Thank you very much for this. This is really interesting. And I think without further ado, I will move now to our second speaker. Navraj, the floor is yours. I'm looking forward to hearing your presentation.
Okay, thank you very much. And again, let me just thank you very much for the invitation. Really very much appreciate it. I'll start off with some biographical words first. I come to this as a climate lawyer. I'm not an environmental lawyer, and I have in the past done some work on labour law, primarily, well, almost exclusively collective labour law, and have always had very strong connections, sort of scholarly connections and personal connections with labour lawyers and people from a social democratic background. And so my work in this area, in the Just Transitions work, my formal written work, really started off with to me that looks inverted. I'm not sure if you can see it. But it's a relatively new book. I think it was published either at the end of last year. So it's called The Constitution of Social Democracy, and essays in honour of Keith Ewing. So Keith Ewing, as many will know, is a very distinguished public lawyer here in the UK, but has also written extensively on European and Canadian and other forms of labour law and also constitutional law. And this is a book about the influence of Keith's work and how social democratic approaches, the basis for them and the arguments that they're made. And it crossed my mind that the field in which I work, the vast majority of my work, that is climate change law, has a very different set of sensibility, because it's a subset of, there's a significant overlap with environmental lawyers, and it has a very different sensibility from what I would call my home, my intellectual home. That is, it is a field of law which focuses not exclusively but substantially on individual rights. It is a field of law which has great faith in courts, or at least has great recourse to courts, and a belief in courts as progressive actors, and so on and so forth. Whereas labour law and social democratic theory has a very, very different set of concerns and sympathies. And so, it occurred to me that, the interface between, or the relationship really, between social democracy and environmentalism is very uneasy, to say the least. And so, as I say in the chapter in this book, at a high level of abstraction, social democracy and environmentalism have generally existed in a state of tension, if not indifference. Social democracy is variously defined as a form of compromise between capitalism and socialism, and its socio-economic objectives tend to be advanced politically, with courts being marginalised, whilst legislatures pass the law and scrutinise the executive. So these are two very, very different sets of intellectual traditions, and they come together very nicely in the Just Transitions agenda. And I think it's worth firstly thinking about the two elements of this term. I'll get to the justice bit in a moment, but when we talk about transitioning, the standard way in which climate discourse talks about transitioning is in energy systems. It's a technological challenge. How do we get from coal and oil and gas and nuclear to renewables? That's fine, but whilst it's also a technical transition or technological transition, it's also a socio-technical system, in which humans are involved and human systems are involved, and livelihoods and institutions and corporations and governments, and they have to change as well, and their lives will be changed. And so just as the kit has to change, just as the those big machines and the engineering has to change, human life will have to change as well. And I think we want to do that from in a way that's informed by what we know about justice and the work that we do about justice, so that that transition, that change is fair, appropriate, and equitable. And the energy transition literature has for a long time operated in a direction which is quite distinct from the justice agenda. So, part of what Just Transitions scholarship and practice has to do is to bring these two things together. In terms of the substance of justice, justice obviously is a vast field of learning, and what we tend to end up with is a form of adjectival justice. So it's not just justice, it's a particular form of justice that's prefixed with a particular adjective. And the adjectives that I'm going to focus on would be distributional, procedural, and justice as recognition. But I'll get to those in a moment. So, as David has said, there's just transitions as a field of scholarship and practice was very much based in with a focus on workers in not just the fossil fuel sector, but really in the coal sector, and has broadened in the last 5 to 6, 7 years, both in terms of the actors in question, so beyond workers, but also beyond those sectors. So that now, as was indicated, it's really refers, in some of the understanding, as it refers to all social groups in all contexts, in all transitions. And I must say, I feel somewhat ambivalent about this. To some extent, it makes sense in that energy is, as we know, a small, very small part of the of decarbonising our systems. Roughly 20%, with another fifth coming from transport, another fifth coming from industry, another fifth coming from agriculture and land use, and so on. So it is a discrete part of the process. So to that extent, just transitions need to move beyond it. On the other hand, one of the virtues of the Just Transitions focus on workers is that this is one of the very, very few areas in climate scholarship, and I'm going beyond climate law, but in climate scholarship, where workers have a space. There are, in climate change discourse, we'll talk about a wide range of other actors before it gets to workers. So let me just bring in the idea of the interaction between the different forms of justice that I mentioned earlier. So in order, this is not hierarchical order, there would be distributional, procedural, and justice as recognition. So distributional justice is the issue, is the what. What is the challenge? Where do you site your facility? How do you deal with the lack of access to a technology? How do you deal with who the winners and the losers are? And sometimes distributional justice will not lead to perfect justice. The best possible application of distributional justice will not lead to an ideal outcome. So if you think of, say, a wind farm, a wind farm will always have to be located where the wind blows. A nuclear power station will always have to be located near water, and you can't do anything about that. So then you have to shift to procedural justice, and procedural justice asks the what question. So what do you do about this? How do you resolve these problems? And it might be, and the solutions might be solutions around compensation. So compensation for workers whose lives are disrupted. It might be anticipatory compensation. So, stopping people from using their land before you want to do something else with it. But also training, in a strict labour law context, ideas about training and reskilling are obviously central to all of this. And then the third limb of the application of justice in this would be justice as recognition. So who do we understand to be the vulnerable groups? Who do we understand to be the responsible groups? And who's protecting them? So, when we talk about justice as recognition in the climate context, typically we talk about the poor, the marginalized, those who are vulnerable to the impacts of climate change. There's a strong gendered aspect to this, but we tend not to think about workers. But workers are one of will tend to find. Thank you. 5 minutes. Tend to find a home in just transitions and very few other places in the discourse. So I think there's virtue in a narrow definition here. In terms of practical action, how do we operationalize just transitions? There are, obviously an increasing number of examples. The European Commission is currently going through a process of, the just transition being one of the major limbs of the European Green Deal with 18 billion euro funds, but they don't really know what they're doing with it. It's all extremely high level at present. A different European Union initiative is taking place in the Regional Policy and Energy Directorate. There's a Just Transitions platform. There they've done very much more granular work with coal communities, principally in Central and Eastern Europe. And a third example would be from Scotland, where the Scottish government has established something called Skills Development Scotland, which is a governmental body which is running pilots and policies and essentially learning how in this space these ideas about reskilling can operate in the context of the climate emergency. And one thing that emerges from this is that all just transitions are highly contextual. So in the case of Scotland, we have a large oil and gas sector declining rapidly, but large, with enormous cultural legacies, of the energy technologies in Aberdeen, but also right along the value chain of oil and gas, where individuals have identities, there are collective identities around this. So it's not just transitions for one or two people, but entire ways of life for communities, and this is very much where you see the limitations of ordinary procedural justice. To the extent that ordinary procedural justice is about consultation, which tends to satisfy absolutely nobody, you see the reskilling and retraining, things are much more tangible, much more satisfying. At least in the pilots that we've seen, have been considerably more successful. And the Scottish Government has got a lot of data on this. I suppose another consideration is the ripple effects of this, and where it's essentially concentric circles of just transition. So you can focus on the oil workers who are directly affected by, say, the non-issuance of licenses for new extractive industries. That's one way to focus on this. But they also have partners, they have jobs, there are service sectors, service industries along the value chain. So the issue of the application of justice really has to engage in some sort of line drawing exercise. Are we focusing purely on workers, or are we going broader to their families? And does that have implications for the operation of labour and other forms of social welfare law? Do we go even broader to the service sectors and so on? So line drawing, who is in, who is out, is also a very significant part of this. So I'll leave it there, and thank you very much.
Thank you very much for this intervention, Navarro. This was also very, very interesting, and I already have a number of questions popping up here, but I'll leave those for the discussion after we've heard also Sania's presentation and our discussants. So Sania, the floor is yours.
Great, thanks. I have a PowerPoint, so I'll just share that with you. Let's see, from the start. Does everyone see that? I assume so. Yeah, great. Okay, so first, again, I will echo this thanks to Kalina for organizing today's webinar and opening a much needed discussion between labor and environmental lawyers. So the first session, as Kalina has already explained, is on the intersection between labor and environmental law in the just transition and the sustainable development context. And just as Navraj and David have outlined, the various steps that could be taken, my presentation or my talk will address the issue or the risks if no action is taken, and action is taken without thoughtful consideration of the steps ahead. More precisely, what I will briefly talk about is exploring the intersections or interlinks between labor and environmental law in the context of populism, which is a major threat to democracies not only in Europe, but worldwide, in the way that, as Jan Werner Müller describes, that it's anti-pluralist and antithetical to liberal democratic institutions. So I will briefly outline and explain how labor law and environmental law are deeply interlinked with populism. Labor law in the way that it contributes or is a contributing factor to economic and social precociousness in personal work relations, and environmental law in the sense that it ultimately creates winners and losers, relies on expertise and institutions, and in this way is an obvious target for populist rulers. So we've seen, for example, the yellow vests provide a great example of how attempts to provide a climate transition or the road to a more sustainable development caused populist wave to take hold of France. But could, however, labor lawyers and environmental lawyers, by joining hands, provide an antidote to populism? And if so, how? So this question, or the answer to it, I should really stress and underline, is really aspirational, in the sense that what I argue here is really what I see as the start of the debate, as opposed to a blueprint provided. I should also underline that I'm not a labor lawyer, I'm an environmental lawyer. And so what I say about labor law, I really say as an outsider to that specific legal discipline. Okay, so having set that out, my short presentation will focus on these three acts. So the first will be to draw a so-called Venn diagram, and I won't actually draw a Venn diagram, but I will map out the interlinks between populism, labor law, and environmental law. What do those three have in common? Why do we need to think about them together? Then I would pause and take stock. And this is a two-step analysis. So one, to take stock in light of the current pandemic. So is populism still a relevant consideration? Do we need to be wary of it? The short answer is yes. And what is more, and this is the second point, is that the risk, the post-pandemic economy provides perhaps an excellent opportunity for labor and environmental lawyers to collaborate. So here I would talk about the greening of markets and how labor and environmental lawyers have both a market constituting role and how that role should be exercised with fairness and inclusiveness in mind in order to really address populism. And the final point, I will try to marry environmental and labor lawyers by really thinking about or musing about how the structures of creating an inclusive governance focused on the rule of law can be carried out. So those are in general words, today's presentation. So drawing a Venn diagram without drawing a Venn diagram. So what does populism, labor law, environmental law have in common? So in order to establish this link, we first need to ask ourselves, well, what is populism, even if only briefly defined? So it's part of, we're part of a so-called populist zeitgeist. The term, however, although it's prevalent, it is very slippery. So it's slippery in the sense that it can be ascribed both to left and right-wing governments. It can be construed as either an ideology or political strategy. We can use a different range of taxonomies to discuss populism. However, there are two key definitions or common traits of a populist movement, a populist rule. One is that it's anti-pluralist. So this means that populist politics draws a distinction between people, which it represents. We know that and the elite, which is then the people's antagonist. So although who the people are is not always clear, it's always anti-pluralist. That is the common trait. And the people who it tends to represent tends to be conceived as a moral entity rooted in moral claims. Populist rules tend to be furthered by one specific leader that tends to be charismatic in nature. And that leader that represents the will of the people. And because the will of the people is grounded in morality, that means that people or their voices are always right. So this means that as a consequence, any opposition, whether institutional, from within or from outside, is seen as a threat to the people. This is why NGOs or courts tend to be seen as or targeted as enemies of populist rules. This is then linked to the second common trait of populism, and that is contrary to liberal democratic institutions. So clearly, populists are impatient with procedures, and they prefer a direct communication, as we've seen, for example, in the US, between the leader and the people. And therefore, institutions, procedures are often targeted. So how then does labor law and environmental law come into the picture? How are they linked to populism? So in terms of labor law, there is a rich debate on labor law in the age of populism. And this is spearheaded by Alan Buck and Mark Friedland, and they examine the interlink between populism and regulation of personal work relations. And they focus their study on the UK and Europe, setting out the claim that precarious work relations have endangered democracies. So this literature is very rich on engaging with the theoretical debate that exists, and it looks also at the history of labor law. I won't have the time to recap all of it here, but the story is that modern labor law politics has created winners and losers. And this is the article from FT from 2017 that illustrates that, which has fueled populism amongst those on the losing side of the economy. So a similar story exists in environmental law, and this is very much based on a commentary written by Liz Fisher, who discusses relying on the empirical evidence provided in Strangers in Their Own Land. In this book that I've highlighted here, provides how environmental problems and environmental law are really the flashpoint for populist politics, and this for two reasons, as Liz Fisher points out. First, the argument is that populism thrives on the frustrations that environmental law gives rise to. So in brief, environmental law requires people to acknowledge environmental problems as problems that concern everyone. What this means is that it requires collective action. And this is what also Navraj referred to. It also requires a change in lifestyle. So even if we all benefit from improved environmental standards in the long run, in the short run, we will have winners and losers. Second, and following from this, environmental law has developed complex governance structures. It relies on environmental decisions that are robust, legitimate, and fair as they can be. It engages with expertise, and as such, it relies on a constitutional democracy, as I have explained. Populism is very keen to take a dig at. So this is to say that both disciplines provide fuel for populism. Even if environmental law, one could say, or to generalize, does it by raising environmental standards, and labor law arguably when it lowers labor protection. So the three are part of the specific diagram. Okay, so we need, this is the backdrop. We clearly need to take thoughtful action in addressing this risk. So, however, could what I've explained now just be part of a pre-pandemic jitter? Is this part of the old world that we don't or no longer exists? So many hope that the current pandemic and COVID-19 would have killed populism, showing instead that we need society relies on collective action, leadership anchored in science and institutions. However, so having killed populism was thought or hoped to have been the silver lining of the pandemic. Unfortunately, as we see in many corners of Europe, populism lives on. What is more, the risk that it will intensify with current plans to deal with the pandemic, which includes revamping the economy, and in doing so, pushing for so-called green jobs and green market. So as we see here, this is a journal article that I found today of exactly the clash with pushing for a green economy, but without taking into consideration labor standards that come with it. So how then, and this is my final slide, how then do we go about dealing with these risks of populism that are only here to be feared even more? And as a start, we first need to acknowledge that both labor and environmental law enjoy so-called market constituting role. And this is very much the wording that I've taken for Simon Deacon, who writes about labor law in this way. So in terms of labor law, Deacon explains that labor law regulation has the capacity of forming the type of markets we want and the markets we need by correcting market outcomes where they lead to negative externalities and limiting the market where this is necessary to actively achieve human development goals. Similarly, environmental law, and I won't go into much discussion here, this is something that I have written about in terms of carbon markets. We see that markets in environmental law can also be structured in many different ways, depending on what we identify the problem to be. So in engaging in this exercise in creating a market, we need to acknowledge that labor and environmental law cannot be called upon simply to fix the market, which is often the call in the new rhetoric in dealing with the debt that has followed the pandemic. So it's not just about internalizing externalities and in this way create growth. We need to address and take stand to what exactly growth and recovery means. Does it entail rescuing, for example, petrochemical industry, which is at risk of becoming a stranded asset on the road to low carbon economy, just as we did with the banking crisis in 2008? Can we expect frequent exemptions from state aid rules, for example, when it comes to aviation and maritime industry, which are under continuous strain during the pandemic? And what about fossil fuel subsidies, for example, to fisheries and farming? So these are sectors that often support small and remote communities. How then should we weigh that against the damaging effect that these subsidies have on the environment? The list here is long. So in rethinking or in mapping labor and environmental law, we need to take some hard decisions. So what is the first step in this regard? And and this is very much, again, coming back to Boggs and Friedland's piece. They talk about creating so-called anti-populist labor law. And they build on Kant Freud's pluralist constitution. So they list a long list of action points of creating, for example, constitutional provisions or protection on the fundamental rights of migrants at work, and so on and so forth. So a key point that they set forward is that we need to create inclusion for all workers in this constitutional system. So could a similar anti-populist environmental law be imagined? So major criticism of EU climate and energy policy to date has been that it's very distant to its citizens. So it's therefore interesting that the new European climate law, which was approved last week, is outlining the objectives of carrying out so-called inclusive and accessible dialogue at national, regional, local level in reaching for greenhouse gas emission reductions. So we need to be creative in the type of laws that we set out. And finally, the point that I want to end on is that populism takes a direct swipe at the rule of law safeguards, institutions, expertise, deliberations, plurality. And as such, it's a direct threat to both labor and environmental law standards. So to counter such attacks, we need to appreciate and include populist attacks on these standards as violations of rule of law safeguards. So that is, I apologize for running over time, but that is the end of my presentation.
Thank you very much, Sanya. Only a little bit over time, it's all fine. Thank you very much. Also for this very different and I think quite new perspective on this topic. So before I turn to our discussants, I'd just like to remind, if you have any questions for the speakers or also for the discussants, please post them in the Q&A rather than the chat if possible, so that way we can have them all in one place. So yeah, thank you for that. And I turn now to Paolo.
Thanks, Kalina, and thanks for all the panelists. I must confess, first of all, this is the first time I play the role of a discussant in a seminar. So I'm not sure I will be very good in playing this role because normally I'm discussed and very much contented in presentations. So I will try to be not so bad in playing this role. First of all, I want to say that it's very good we are discussing labor lawyers and environmental lawyers, climate change lawyers, all together here of questions, issues of common interest. I think dialogue between us, between different disciplines, is very important at this stage. And I thanks a lot Kalina and ETUI for having organized this seminar, which is very important. And the fact that we are discussing different ideas of justice, I think it shows that the old industrial social contract is broken, and we are here to try to figure how the new pillars of a new social contract, under which new ideas of justice, which are more concerned with not just social justice but also ecological justice, will look like in the next future, in the near future. And today we are not able to draw lines saying that this is justice, this is not justice. The one thing I can say is that nobody argues in favor of unjust transition. All of us are convinced that we should find ways and paths to promote a just transition to a low carbon sustainable, zero carbon sustainable economy. And I also want to underline the level of discussion. Actually, before hearing your presentations, I thought this seminar would have been different. I mean, I thought we could have discussed, for example, on general principles of labor law or general principles of environmental law or climate change law, and discuss how these different principles or convergent principles interact in different disciplines. For example, if we take key principles of labor law, such as the prevention principle or precaution principle in relation to occupational health and safety. My expectation was how this interact with the same principle in environmental law. But we are not discussing at this level the intersection between the two different disciplines. We are on a higher level. I would say we are all taking a social legal perspective on these intersections between the different fields that we are talking about, and not at this stage a positive law perspective. So this is the one point I wanted to make, but perhaps it was just my expectation that was not related to the higher level of analysis of the problem. And I expected just different aspects to be discussed in this seminar. But it's good to have started now, and perhaps in next seminar we can broaden the discussion to more specific positive law aspects of the intersection between labor law and environmental law. I share with David and Navraj the risks of a broader vision of just transition, too broad, vague, meaningless. But I also share the opportunity to have a broader view of what just transition is, and the very different concepts of justice behind the idea of just transition. And I would like to focus on these different ideas of justice, those that David mentioned, especially in his presentation. And here the biggest problem I see does not refer to contestation between different ideas of justice between disciplines. I refer to the complexity of providing an internal definition of justice within the boundaries of each different discipline. For example, David, the slide you showed about the concept of justice in labor law, in the other discipline, it will need to open a big internal discussion also between labor lawyers on what is justice in the context of just transition. And I think we will come up with very different ideas. If we look at industrial relations literature, for example, we find a number of taxonomies on union strategies about just transition, and each of which reflects different ideas of justice. And I think the same goes for environmental law. So I think we have to make this distinction, which was mentioned by Navraj. I see Kalina, I already
we have to interrupt you.
Just
finish up.
Yeah, really? Not 1 minute more? Can I? Okay, I'm zero. Sorry, I was very bad. I was very bad in discussing the 3 articles, but the time was too short. Sorry.
Too short. No, that's not a problem. I understand, but you made some really good points, and I think maybe at this point I will add that some of the points that you raised about more particular discussions, such as occupational health and safety, they will be the subject of a presentation in the second panel as well. And so, but you're right to point out that there is this difference between the more general level and a more particular level. And I'm sure that the others would like to respond, but I'll first also give the floor to Loveleen to make her comments and questions.
Yeah, thanks very much, Kalina, and thank you so much to the speakers. That was super interesting. I am an environmental lawyer. I also claim to be a climate change lawyer sometimes, but I do most of my research in India, where you do sort of see the intersections between environmental law and labor law. You cannot avoid it, because the environmental justice movement and the labor justice movements can be quite intertwined in many interesting ways. But just taking a step back and trying to reflect on what the speakers said and what I've read of their work, the one thing that I find really interesting is sort of the idea of transition, which to me signifies something that happens gently, gradually. It's not this sudden moment. And this gentleness and this gradual change that we're expecting seems to be at odds with the different levels of transition that are taking place We know that coal-fired power plants have already closed, sometimes because of exhaustion of natural resources, sometimes because governments have made commitment, but the justness of the transition is definitely somehow lagging behind. I say this also because in India, for example, the idea of a just transition in quotation marks is a relatively sort of nascent stage development. But the idea of just transition in different articulations and different vocabularies has been around for a while. So it's not necessarily new as a concept, but it seems to be newer in its particular articulation in these double quotes of just transition. So yeah, so this idea of transition then also makes me think, so we're thinking about creating a vision, a plan, which has to be a long-term vision, a long-term plan, which means you need to think right now about what's going to happen in 15, 20, 30, 50 years. And what Sanya said about populism all kind of strikes at odd, right? We're talking about institution building, we are talking about procedural safeguards and nurturing them, but the populist state is certainly at odds with that. So how is that going to play out? I think adds another layer of complexity to the other problems we are already seeing with the broadening and deepening of ideas of just transition. Navraj talked about distributive justice, procedural justice, restorative justice, etc. I just wanted to signpost a few things. I find it quite interesting from an India perspective that there's also a huge sort of informal labor force that you have to contend with. And what do you do with this informality of the labor force when you're thinking about application of a just transition idea in a country like India is something that I would be quite interested to hear more about. There's also this idea of sort of geographical location, which again feeds into this just transition conversation. In India, for example, the coal plants are in one place, but renewable energy is not going to develop at the same places. Renewable energy projects are likely to develop in other locations. So we cannot then automatically put the workforce from the coal plant into the renewable energy projects. The kind of expertise that is required for renewable energy projects may also be quite different. And I think this goes to the point that David was making about skill development, expertise, etc. So when we're thinking about this kind of just transition, again, this idea of the vision and the plan becomes quite significant if you're going to contend with all of this. There's also this question of mobility, which is related to the fact that there is this geographical relocation. There's also this interesting dimension of the fact that in India, the railways is one of the big consumers of the coal. And the railways cross-subsidizes transportation, which then allows the workforce to move from one part of the country to the other. So the kind of knock-on effects that just transition or unjust transition might have is also something that we need to think about. David also made the point about ghost towns, and I think that's an interesting one. And this really feeds into how environmental law and labor law can actually potentially speak to each other. The kind of redevelopment of ghost towns that can take place and the opportunities for ecological restoration in those towns and the involvement of potentially the workforce from those coal plants in these restoration activities could be another thing when we're considering sort of just transition at a micro level. So I suppose the bottom line really for me is that two things. One is we're thinking about an individual and a collective aspect. And if you're talking about procedural justice, we also need to ask ourselves, where are the opportunities for the development of a collective labor force in these renewable projects, for example, given the scale and the strength of the workforce. And the other thing for me to consider is also sort of the granularity that Navraj mentioned in his presentation, the fact that we are kind of talking about from an international to a national level sort of understanding, but we also kind of need to take it down to the local level because these decision-making processes are very much hands of sort of local representatives, both of the government and of the labor force at the local level. So in light of that, I suppose I have kind of three questions, which are perhaps very broad, but I'm just going to put it out there. And I think for David, my question was, because you expressed a concern about where labor law was in all of this. And I was just wondering, how do you think we can reinstate labor law into this kind of broader just transition discourse, if you like? And I know it's a very broad question, but I was just wondering if I could get your thoughts on that. For Navraj, I think my question was more about how do we make this transition from this de jure just transition narrative, which is developing, to sort of a de facto just transition that is going to take place on the ground, given the kind of disparity among jurisdictions. And I think for Sanya, my question was really what I was saying at the outset, this idea of needing an active state, an active state that can also kind of create these institutions and these procedural safeguards. But then we also have this quite strong move towards deregulation in so many other ways. And then if you put this problem of populism in the basket, as you mentioned, like, what do you think about how do we balance these really sort of problematic countercurrents? I'm going to stop with that. Thank you very much.
Thank you very much, Loveleen, and also thank you, Paula. I think you both raised some really, really interesting points and questions. And I think before I ask more questions, I think I'll give the floor to David, Sanya, and Navraj if they would like to respond. So maybe we'll do them in order. Maybe David, starting with you, if you would like to say something.
Well, thank you very much. Those are very interesting talks, very interesting discussants. I guess I'll respond to the specific question that Loveleen sent to me there, and that's a hard one because, for those of us who are, and those in the audience who are labor law people, there'll be an awareness that labor law, a lot of the literature over the last, say, decade has been about the so-called crisis of labor law. And the idea that a lot of the ideas that have underpinned the labor law field in the last 60, 70 years are under strain and being questioned. And so there's a wide scholarship on, how to reinvent labor law. What's the future of labor law? And part of that arises from the fact that historically labor law has really focused in on collective bargaining law and in unions, and throughout much of the world, union representation is declining. And as that happens, labor law itself is becoming more marginalized. It's getting, less interest. It has academic effects, but it also has real effects. So labor departments, labor ministries are getting less resources. So we're all engaged in this discussion about what's the future of labor law. And then when you draw in, the just transition and the climate issue, there's a real possibility, I think, that labor law could become, within that broader discussion of just transitions and climate change, sort of a narrow technical discipline that's buried down in the bushes, talking about, occupational health and safety regulations and almost like it's the whole debate within law generally about, are we big theoretical thinkers, or are we plumbers down there just, so labor law might just become the area of law that implements some of these big ideas that people in other disciplines are coming up with. And so the goal for labor law people is, well, we don't want to be the plumbers. Nothing wrong with plumbers, obviously, but just to use the analogy, we don't want to be the people changing the pipes. We also want to be the people way up at the top planning infrastructure and big important questions. So that's what's going on in labor law scholarship. And so if you bring it back to your question, one of the things that we do really well in labor law is thinking about law's role in creating collective voice on big important public policy issues. So it's possible that maybe labor law needs to move, take what it knows about empowering worker collective voice in a workplace setting, and take some of those historical lessons to think about law's potential role in elevating the voice of not just workers in a workplace, but communities and groups, and figure out ways that they can have, procedural justice, to use the language that's often used that Navraj talks about. Maybe labor law isn't just only about voice in a narrow workplace. Maybe labor law is about how law can encourage collective voice in society generally. Maybe there are lessons that we can play there. But these are hard questions, and I think it's something labor law people are quite concerned about, that maybe we're being left behind in this big discussion. Just transition started with the labor movement, but the labor movement is almost secondary to it all now. In many of the broad discussions. So I don't really have a satisfying answer to that. I think it's one of the big questions that we're talking about. And by the way, it's not many of us talking about it. Like a point I made, there's just a handful really of labor law people who have tried to dive into the climate discussion. It's hard, right? It's just really hard because there's so much we don't know about these other fields. I had never heard of this is how stupid I feel. I had never even heard of environmental justice and an energy injustice until I was asked to get involved in this project, because I don't read that literature. And that's true of most of my colleagues, right? We read labor law literature and high theory, but we don't read environmental law very often, and we need to. Anyways, I'll stop there. That's a long answer that didn't actually say very much, but.
Thank you, David. No, I think it was long, but I think it was a very interesting answer and very on point, especially about the lack of interaction between the two fields, and that's why we're here today. Navraj, if you would like to respond as well.
Sure.
To the.
Can I? There's so much there. Let me just say something about methodology and the way that lawyers work, and this perhaps relates to what David was just talking about. Lawyers and certainly legal scholars tend to be lone wolves. They tend not to work in teams, unlike natural scientists, for example, who work in labs and interdisciplinary combinations. And I think that makes the job of just transitions for lawyers much harder, because not only do you need to know all of your core work, your labor law in one person's case, but you also need to know all of this stuff that's going on in environmental law, and you need to know the stuff that's going on in the social sciences about this. And unless you're Leonardo da Vinci, that sort of ability to be a polymath just isn't at your fingertips. So that's really about the structure of the way in which we work. And that's the way in which legal scholars work. I don't think is particularly conducive to these transdisciplinary problems. So that's just something about method. To answer Liveline's question, in the chat, I've just put a link to a project. So this is a climate strategies project about coal transitions in a variety of different jurisdictions. I'm the chair of climate strategies, although I wasn't the chair when this body of work was done. But one thing that you get a sense of is just the diversity of potential, challenges, potential solutions in jurisdictions such as these particular ones: China, India, South Africa, Australia, Poland, Germany. Now, in one sense, you might say, well, that's obvious, and you would hope that that is the case, and of course that's right. But I think it really goes back to my point about the deeply contextual nature of any answers to these problems, and that really the only thing that they have in common is a process about understanding what the nature of the energy transition is, or may not be an energy transition, maybe a transition in the food and agriculture sector, or transition in the materials sector. It doesn't really matter, but understanding what that is in a very practical sense, which means widespread engagement between that classic labor law tripartite relationship, right? Workers, government, and industry, and in the absence of that, any basic understanding of what just transition entails is elusive, I think. I think more technically, I suppose, about how to make a transition de facto. There are a number of processes going on that are worth bearing in mind. At the multilateral level, at the UNFCCC level, there is the Marrakesh process. I'll just find the link for you. The Marrakesh Partnership, which has bearing on the just transitions processes. There are various databases, and I'm just dropping in another one, of green collective agreements. I think for our purposes, I'm not sure that these are terribly, are as deep as they might need to be, but they're examples. And just transitions commissions, again, as a tool to develop, very granular, local, contextual, understanding about the, who is affected, who is responsible, what are the viable technologies and approaches and social systems to deliver a form of justice. I think the Just Transitions Commissions have been a model, at least that ought to be considered wherever just transitions are to be embraced. I mean, one final thing about how one can, the nature of the transition. Okay, so transition apparently needs to take place, and if you believe what I believe, you think it needs to take place really quickly and very deeply, and so on. And people of a different persuasion would doubt that, and very frequently they are trade unions because they have members who are deeply implicated in a particular sector. And so a recent example in the UK was the Heathrow Airport judgment, which when the Court of Appeal said Heathrow when the Supreme Court said that Heathrow they wouldn't overturn the decision on the extension of Heathrow, the GMB union and their workers, were on the streets and celebrating and so on and so forth. Perfectly understandably, but the opportunity cost of a stranded asset also needs to be factored in. If this infrastructure is built, it will be stranded, and the stranding potential, the consequences of that stranding rest not only with workers, but also with pension funds who finance these, and with the broader economy and implications for financial stability. So the alternative of not proceeding and stranding is also a live issue here.
Thank you very much, Navraj, for these comments. I will go straight to Sanya for give her an opportunity to respond, and then we don't actually have that much time, so then I'll open the floor to some questions from the audience.
Great. I'll echo the other speakers to say there's just so much to discuss here. I have 3 points to make. One ties back to what Navraj has said about how lawyers work, in the sense that we work in solitude and silos. And it's not only how we work, but it's also how we teach. And I think this is important. So we tend to, we're very exotic in environmental law by claiming or by engaging in interdisciplinary kind of collaboration, but there is also need for intradisciplinary. So for example, a couple of years ago, here we teach environmental law by including a property lawyer and an administrative lawyer who don't identify as environmental lawyers on the course, just in order to show that we need expertise from a wide range of lawyers in kind of addressing environmental law challenges. So I think both how we work and how we teach needs to be rethought. And kind of now coming back to Loveling, your question more specifically, the relationship between populism, regulation, and the active stage. I mean, here it's really kind of, again, coming back to Navraj's point about we need to take some hard decisions about, I mean, one, do we want to deregulate? And even if we decided to deregulate, there are many ways of deregulation. So the market can be structured in so many different ways and forms. So it calls for deliberation and participation. And the question is, well, who gets to participate, on what grounds, on which basis, who gets to review that participation or that contribution, who's ultimately the decision maker? And this I thought was really interesting what David said about labor law providing a kind of a possible forum for participation more broadly outside of labor law. So I think there is a definite point of connection between labor and environmental law that I think should be explored. And kind of finally coming back to the point about plumbers versus landscape artists, and David, I completely appreciate that you didn't intend to be derogatory to plumbers, but I think kind of anyone who's had a jammed bathroom will appreciate plumbers. And I think we also need to be better at explaining why the plumbers' jobs are significant. To me, what we've discussed so far is really, and this is kind of the third point that I discussed, is really a rule of law question. It's not simply kind of the technicalities. If we don't get our bathrooms in the order, the whole house will be inhabitable. It's where I will end my answers.
Thank you very much, Sanya. I think given the limited time, I might ask some questions from the chat. If there are more questions from Paolo and Lovlin, and we have time at the end, then maybe they can ask those as well. So some of the questions, and these are from Mauro Puccetta and from our colleague Bella Galgosi, I think they've been addressed to a certain extent, which is about the role of labor law in the context of climate change policies, and the role of law, where the role of law is when dealing with climate, environmental, social, and so on types of justices. And I think some of you have addressed it to some extent, about in case you want to say anything more about this, you're welcome to. And I would like to add another question to this, which is actually my question, which is, what is the place of rights? So the labor and social rights, fundamental human rights and environmental rights in the just transition discourse. And so maybe these can be kind of taken together if you want to respond. And then we had two questions relating to the role of workers and worker participation. And one of them was highlighting the importance of the right to freedom of association, and asking if there are examples where workers and the unions have been successful in negotiating binding carbon reduction commitments. And so this is sort of one question. And the other one I think is also really interesting, which is what types of measures or labor laws can we start to enact to ensure that workers are sort of able, even outside the sort of dialogue and bargaining via unions and works councils, to have a more direct input and in decision-making power in the organization of industries to speed up progress on the just transition. So if you would like to, if anyone would like to address any of these questions, just indicate. Navraj. Thank you.
Yeah, just to get it rolling. I mean, I think the big opportunity for the trade union movement and individual trade union members is on the skills agenda, and on engaging with the process and pushing the process of changing the skills system, because there is no question that the skills system needs to be reformed in a very radical sense if the sorts of industrial and social changes which are necessary for net zero, for want of a better word, are going to take place. And those skills are very different, and those processes are very different from the skills of today and yesterday. And you know, this is an opportunity for the labour movement to get ahead of the game and to be shaping that process rather than responding to it. So you know, that would be, you know, one very practical way in which I see the movement you know, responding to this challenge.
Thank you, Thank you, Navraj. Would anyone else like to respond? Also, Lovlin and Paolo, feel free also to jump in if you would like to say something on these topics. David.
I'll just be quick. And now I feel like I'm going to have the Plumbers International United after me. And I just want to say that I love plumbers. And I hope my son and daughter grow up to be plumbers. But I guess one thing I would just say, this is more, I think this probably comes in part from being a North American, where our labor law, collective bargaining laws are quite subscribed. So there are practical labor law questions for us here in Canada and the United States about the scope of collective bargaining that raise real challenges. It's not easy to, bargain topics beyond the workplace, which a lot of this does. It's very difficult under our legal model for workers to go on strike, to try and win things that are not directly related to the workplace. But that's one point, and there are different considerations in Europe and other international collective bargaining law systems. But one thing, this again comes from my background as a practicing labor lawyer and general counsel, particularly in a union that represented coal miners and other fossil fuel workers. It's a challenge. One thing you have to think about from a labor law perspective is sometimes the things that the leadership of unions think are a good idea because they're thinking at a meta strategic level aren't always what the workers down on the mine and the shop floor think are a good thing. And I saw that, in my own practice back then, where, up in head office of the union, we would come up with these great ideas for, in trying to get environmental wins. And you bring it down to the collective bargaining table. And if you ask workers to trade off, a raise or job security or something, a pension for some sort of nebulous climate language, you'll usually lose the climate language at a practical level. And so I think it's one thing to think unions are complex, and they don't always have a unitary goal. It's more complicated than that. And that is a matter, so labor law is a challenge. Sometimes it actually makes it difficult to implement strategic level, societal good type wins through collective bargaining. And again, I may be influenced by North American system here. But traditionally, we are focused in on quite narrow workplace level things that don't always translate and don't always win unions a lot of allies beyond the workplace. For instance, if unions are arguing for certain benefits for their existing coal miner members, that may not win them friends in other interested communities. Unions might end up looking like a special interest group that's only trying to protect their few workers that are left in the fossil fuel industry, and these are complex issues. Anyways, I'm not sure if I addressed anything there, but I just felt like jumping in on that point. Go Plumbers.
Thank you very much. Sonia, would you like to add something?
Just very, very quickly. And I just want to say, I do apologize, David. There was absolutely no purpose. I really didn't attempt to put you in any uncomfortable seat with my comment. Just as a very, very general answer or point to our discussions. And I'll again refer to my brilliant colleague here, Liz Fisher. She talks about, in dealing with future and current challenges, we need legal imagination. And this is a concept that she's currently working a lot on. So testing concepts, both old and new, from law and elsewhere, to see whether it fits in dealing with the challenges that we have. And just reading the chat. So there is a question here from Katharina Bunnenberger, who says that, should we, for example, have, right to decline environmental harm tasks in jobs, and how would that look? And she's suggesting, and I think this is exactly the kind of the discussions that we've had today, looking to other legal disciplines, thinking of, are environmental rights the way forward? Can unions provide something to the discussion? What is actually the problem that we are just addressing? Is it the workers in the coal mines? or is it something else? What kind of market do we want? What kind of market do we need? What are our role as lawyers from these different disciplines in creating that market? Who should ultimately have a say in constructing that market? I think what we've seen today is exactly the kind of discussions that I think will take us forward. Thanks.
Thank you. No, thank you, Sanya, very much. Just a couple more questions to raise, unless if anybody else wants to add anything at this point from speakers or discussants. No. Okay, I'll just raise some more questions. Again, my colleague Bella corrects me in the way I stated the question. I think his question was also about what is the role of law as opposed to different types of policy making, taxes, incentives, and so on. Does law have a different role to these types of incentives when it comes to addressing social, environmental, and climate change concerns? And so all of you are lawyers, and I actually think this is a really good question to discuss in the present company. And another question also from the chat was about the geographical scope, the territorial scope of labor law, and perhaps also the fact that environmental law has a different, not just geographical, but also temporal scope. So looking at long-term global problems, whereas labor law usually looks at shorter term and local problems. And so one, I think, also important question would be how can we reconcile that, and where can the two disciplines meet somewhere? So maybe I'll throw those two out there. I think they're both quite interesting. If anybody would like to, David?
Well, I can go on the first question. I mean, I think if we think about the strategy here, we're talking about transitioning away from high carbon and transitioning to low carbon economies. But also we are talking about in the process of doing that, ending up with good paying jobs in the new economy. And, you know, there's a lot of, like, in terms of the implementation of these dreams, these policy dreams, there's going to be a need for a lot of law. Law is how we implement a lot of these down on the ground. So if we think about the good jobs part of it, if we want to come out of this with good jobs, well, law has long played a role in trying to create good jobs. Now, more or less depending upon where you live. But I mean, certainly in North America, law plays a very large role in the pursuit of decent jobs, right? Through both the ways in which it regulates collective bargaining and also labor standards and health and safety rules and pension laws and so forth. So I don't see, and again, I know there's a long tradition in many other countries, Britain in particular, Britain for sure, of sort of a laissez-faire, stay out of it. But certainly from a North American perspective, if we're going to come out of this with good jobs, then the way that's going to happen is in large part through law. The market's not going to create these great jobs. What's going to create the great jobs is partially the market forces, but also the way in which we regulate work. That's just one example from labor law, but that's why, for example, you know, in the Green Deal, you know, the American Green Deal, there's stuff in there on collective bargaining law, right? It's not just, you can't just create new jobs. You have to create new jobs and then make sure that workers are going to be able to engage in collective bargaining, and there's a role for law there. But then, you know, there's lots of other examples, you know, immigration law. Like if people are going to be able to migrate and move to where the jobs are, then we need to ensure that there aren't at least legal impediments that stop them from moving. So, you know, and the right to work, and who has the right to work? Well, all of these things are affected by legal rules. So in terms of the implementation of a just transition, we need to be really aware of how it's actually going to happen. It's not, law is what implements policy. So I think there is a big role for law. And as we've said, a lot of people have said here, the challenge is the laws that we're going to need are so cross-disciplinary that we need to start speaking to each other. You know, we're going to need not just labor law, we're going to need all these other areas of law, or people are going to have to start learning just transitions law. That's why I got into that whole discussion. That is by its very nature, a cross-disciplinary idea, right? You don't just come out knowing labor law, you come out knowing 6 different fields as they relate to climate. That's a different way of teaching, a different way of learning. I'll stop there.
No, thank you, David. And I think, yeah, I think I agree with much of what you said. What you said there was very interesting. Would anyone else like to address these questions? Perhaps also the one on the differences between global and local level. Navraj.
Yeah, just building on what was just said. You know, the transition to low carbon societies and economies will necessitate whole new technology sectors. You know, technologies which do not exist currently will have to be invented, are being invented. Sanya and I are working on a project which is, you know, a massive project which is doing precisely that. If the trade union movement wants to be able to unionize those industries and sectors and workers, it needs to talk the talk. It needs to be involved in the conversation. You know, so that's, you know, just one, extremely instrumental response to this issue. Another is that one of the major actors in climate activism at the moment is the process of climate litigation. Climate litigation is funded not by people at bean feasts at Greenpeace meetings. It's funded by major philanthropies, which are in turn funded by billionaires. These people are and I work very closely with them. They are almost, to a man and a woman, incredibly hostile to the labour movement. They see the labour movement as a bunch of knuckle draggers who are hoping and working really hard to protect, the handful of remaining jobs in the industries that they hate most: coal, oil and gas, chemicals, steel, cement, etc. So if we want to, and I refer to those people in my article as the cool kids of Davos, and these people are phenomenally important. You cannot imagine the money that they have at their disposal and the ways in which they deploy it. Climate litigation is a major force globally. There isn't a jurisdiction in the world which isn't engaging in it, and that includes China. If you don't want to be on the wrong side of that litigation, or at least you want that litigation to be sensitive to the concerns of workers and the labour movement, a big job of engagement needs to be done. Complaining about or celebrating high carbon victories in courts is not the way to do it.
I mean, just echoing, I want to add much to that. I think that the point that both David and Navraj raised are both really important. But this last point, I mean, this is again why today's discussion is so important, to try to think about. Navraj, in the article that is in the chat, you do discuss the foes that environmental lawyers and labor lawyers have been. But in a sense, we do need to rethink that relationship, because there is so much of mutual benefit in moving forward. And again, coming back to my discussion, but this is exactly the point. If we don't do that, each sub-legal discipline is under the threat of populism. So we really have all to gain and very little to lose, I think.
Thank you very much, Sanya. I think, Lovelin, you had a point to make. If you could make it briefly, and then I'm sorry that I'll have to end the discussion at this point.
Yeah, I'll try to keep it really short. I think it was about sort of why law, when we have all these other things. And in an ideal world, and we don't live in an ideal world, so this is not usually true, law should ideally provide you with this sort of stable framework, right? We are talking about accountability. We are talking about systems where if things don't go as they should, you should be able to do something about it. Does this really happen in practice? Maybe not always, but it does sometimes. And to me, that definitely is the strength of law over many other instruments some of the times. And I think this comes up, of course, the challenge here is we're also talking about climate change, great uncertainty. We are talking about flexible laws, adaptive laws, and all of that. But there still is a foundational element of stability, a foundational element of accountability, if done right, can protect many rights and interests. And the other thing I wanted to respond to was about the whole international, regional, and national thing. And I think it's really great to kind of have these international systems, whether it's ILO or the climate change agreements, et cetera, in terms of, agenda setting, getting us all on the same table. But as we've already kind of talked about, the fact that different countries are different, contexts are different, temporally, spatially, et cetera, et cetera. So there's definitely a much stronger room for conversation between labor and environmental law domestically. It doesn't happen in many jurisdictions, but the hope is that with this kind of conversation around just energy transitions or just extractive industry transition, whatever it might be, that this will create that space where scholars and practitioners will say, hey, we do really need to talk to each other. And I think that's already sort of come out quite clearly in the comments of the panelists. Thank you so much.
And thank you very much. I think this is actually a really, really good way to wrap up. And I'm really sorry that I have to interrupt such an exciting discussion. And there were still so many questions, but I hope that the speakers have taken note of them. And I would really like to thank all the speakers and discussants for their thought-provoking interventions, and also the audience for all the questions. I would also like to thank my colleagues at the ETUI, Angelique and Sophie, for their support. Because I won't be moderating the second panel, I won't have the chance to. So thank you, Angelique and Sophie. I've really appreciated it. Also, many thanks to my colleagues, Nicola, Sylvia, and Odd, who for their advice in putting this together, and also to Paolo as well for his advice and for his help. And so thank you all very much again. This has been an incredibly fruitful discussion, and hopefully see you again in about 15, let's say a little bit less than 15 minutes time, let's say, at 4 p.m. So thank you very much. That's it from me.
Kalina, there's now a break, right?
Yeah.
Perfect. Okay, thanks. You just said that.
Yeah.
Sorry, Kalina.
Yes.
I was just going to say I was answering a couple of questions in the Q&A. Is that
thank you.
open?
I think it's still open. Yes, it should be there.
Yeah. Okay.
If you want to answer them, yes. Thank you.
Okay.
Thank you very much, and thank you so much for taking part. It was really
no. Thank you for the invitation. It's great. I'm looking forward to the next part.
Good afternoon, and it's a pleasure to welcome you all to this second part of this afternoon's event. We are about to start with the proceedings of a second panel today, and the second panel of this workshop is exploring the topic of the interfaces between labor and environmental law. So in the first panel, we heard about some of the potential interactions and goals and interests between these two subjects, looking at the context of the just transition in particular. This second panel is slightly different, both in terms of its angle and its format. Here we will look at 3 examples of scholarship by labor law colleagues, which explore the nexus between labor and the environment and environmental law from different perspectives, questioning the jurisdictional boundaries between these fields, and then looking at possible intersections between labor and environmental law, in particular in the sphere of occupational health and safety, and the role of collective worker voice in environmental sustainability. As I said, the format is also slightly different. We will be hearing first a presentation from a labor law colleague for about 10 to 12 minutes, and then this would be followed by comments by a colleague who works in the sphere of environmental law for about 5 minutes. After that, at the end of these 3 presentations, there will be time for questions and discussions. Let me quickly introduce our speakers and commentators in this session. So the first speaker is Ania Zbigniewska, who's an assistant professor at Carleton University in Canada. And she researches the regulation of work and labor markets from a critical socio-legal perspective. She has written on the intersection of work regulation and environmental sustainability, with a focus on legal contestations and conflicts produced by jurisdictional boundaries. So she's eminently well qualified to present on the topic, exploring fragmented regulatory landscapes through a critical lens, pitfalls, possibilities, and methods. Her presentation will be commented upon by a colleague from the Bristol Law School, Margherita Pieraccini, who's an associate professor there. And Margherita conducts socio-legal research on environmental matters, and her main areas of research are environmental law and justice, sustainability, marine conservation, and the governance of the commons. A second speaker is Alexis Bougada, who's a professor of labor law at Aix-Marseille University and the director of the Center for Social Law there. His research addresses procedural and substantive aspects of labor law, both individual and collective labor law and social security legislation. He also writes about the role of collective bargaining, specifically in the context of environmental sustainability, and on the intersections between labor and the environment. Today, he will speak about occupational and environmental health, meeting point, and perspectives. And the commentator is his colleague Mathilde Autreau-Boutonnet, who's a professor of law at Aix-Marseille and specializes in environmental law. She's also the director of a number of research networks, such as the Justice and Environmental Law Network. She has written on a wide range of topics in the sphere of environmental law. Her current research interests relate to the role of private law in environmental protection, including with respect to climate change. The third set of speakers and commentators are Professor Consuelo Chacartegui, who is a professor of labor law and social security law at Pompeu Fabra University. Her research interests lie in the sphere of European social and labor law, discrimination on grounds of gender and sexual orientation, but also industrial accidents and green clauses in collective agreements. And we heard in the first panel a number of questions being raised about that particular institution, collective bargaining. Together with the other speakers in the first panel, Anya, Alexis, and Paolo, she was involved in the comparative agreement project, investigating the role of collective bargaining and social dialogue in promoting sustainable development and just transitions. She will be presenting on the collective dimension of sustainability, labor, and environmental intersections. The commentator of Cello is my old colleague, Professor Chris Hilson, who's a professor of law at the University of Reading. His current research interests are in the area of British, EU, and comparative environmental law and policy, climate law, and climate change litigation, as well as law and social movements, and of course, EU law, which a long time ago we had a pleasure of teaching together. Without further ado, I will pass the microphone to Anya. Anya, you have 10 to 12 minutes to complete your presentation. Thank you very much.
Thank you. I'll likely take 12, but I will be keeping my own time here. And if it's okay, I'm just going to share my presentation. Sorry, share screen. For some reason, it's not coming. Here it is. Sorry, this is here. Okay, thank you very much for inviting me to participate in this seminar. I'll be speaking to this subject, fragmentation, as one defining feature of the labor-environment nexus, or indeed modern legal systems in general. Kalina has asked me to draw on a paper that I published in 2018 in the Comparative Labor Law and Policy Journal. So I will be beginning there and then ending with more recent research and work that I still have in development. My presentation will unfold in 3 steps. First, I will argue that we ought to treat jurisdictional boundaries drawn around labor and environmental matters not as inevitable, but rather as historically constituted and representative of a deeper rift between society and nature that is characteristic of modernity. The resulting regulatory landscape has consequences, as we've already been exploring, and I will be considering in my next kind of step some of the pitfalls which are associated with regulatory fragmentation, and then considering also the transformative possibilities that exist despite it. And finally, I'll comment briefly on research methodologies that may be useful in exploring the legal aspects of the labor-environment nexus. Labor and environmental law are distinct legal fields. We've already been saying this through the first panel. They have unique material scopes and normative foundations. Not only do they scantily cross over, the goals of labor and environmental law, much as the interests which they represent, are sometimes said to conflict with one another. And the notion that there is a trade-off between jobs or development and environmental protection and climate change mitigation, for instance, which is often invoked in public debates and again has come up now several times, is quite paradigmatic of this conflict. And while these conflicts are material, my contention is that they are also constructed and that law contributes to their constitution. From critical vantage point, law's normative, discursive, and jurisdictional boundary setting operates to constitute particular social and socio-ecological relations, and insistence on autonomy of particular legal fields can contribute to fragmentary and partial treatment of phenomena and subjects that are materially entwined. And this jurisdictional this juridical constitution of labor and environment as oppositional or at least disconnected from one another is rendered visible when we situate the development of labor law's jurisdiction and objectives within longer term historical shifts in socio-ecological relations. And this kind of move helps us illuminate the law's historic contingency, but also to problematize its boundaries so that we can consider possibilities of its broader socio-ecological framing or better articulation between labor and environmental fields. And in my 2018 paper, I tackled this question of the roots of labor law's exclusion of the socio-ecological realm from its scope by considering the socio-political and intellectual background out of which industrial work systems and labor law norms eventually emerged. And I begin, with engaging with work of many scholars who locate the kind of development and hardening of the disjuncture between the spheres of society and nature in the period of enlightenment. And I find personally Karol Polanyi's treatment of this bifurcation particularly useful because of his attention to labor. Namely, he notes, as others also have, that the detachment of labor from land through enclosures and commodification of both labor and land were key to this process of bifurcation. And Polanyi also suggests that commodification, or he describes how commodification of land and labor unleashed a crisis across a range of different domains, precisely because of how inherently bound up with each other land and labor, and by extension society and nature, had been. Importantly, he also notes that the multifaceted resistance and pushback that followed this crisis led to adoption of various legal protections for land and labor. But he also shows how the interests of rural populations and landowners on the one hand and industrial workers on the other were ultimately set on different, often oppositional courses during this period, and led ultimately to different sets of protective measures for labor and environment. So this is familiar history that I'm transversing here, but it is important to restate because it reminds us that land and nature became constructed as labor's other, and suggests also why this othering has been reproduced in systems of labor law, which lost sight of labor's essential role as the process that mediates the society-nature relations. And in my paper, I liken the exclusion of socio-ecological issues from labor law's scope to its exclusion also of unpaid work of social reproduction, on which labor and productive activity relies, and which feminist labor law scholars have also shown to be historically contingent and consequential. And the reason I present these two exclusions in parallel is not to suggest that they are exactly the same, but to show how a separation of one's interconnected activities can be hardened through institutionalization and regulation, and then produced over time with particular consequences. So one of the consequences is this stubborn discursive and material oppositionality between labor and environment that is encapsulated by the jobs versus environment dilemma. Indeed, even when there is willingness to deconstruct this oppositionality and get beyond it, law can often stand in a way. And a good illustration of this are historic campaigns by trade unions and workers that sought to integrate or reconnect environmental and labor issues, and have been able to do so only with partial success due to, among others, the limits imposed by the legal frameworks. For example, lobbying for stronger occupational health and safety standards and control of industrial pollution and emissions were issues that in many countries united labor movements, environmental activists, public health officials. In the UK and US, for instance, activist coalitions it was activism of such coalitions that led to passage of first comprehensive occupational health and safety laws in the 70s and 80s. And when they were first enacted, these laws encompassed a much wider understanding of health and safety, spilling in a sense beyond the work side. But with adoption of environmental protection legislation in the 90s, many of the elements, in fact, of this broader environmental protection were progressively excluded from the jurisdiction of health and safety bodies and moved under jurisdiction of the environmental protection bodies. My recent research on unions and workers' activism and workplace bargaining on environmental issues in the UK, which is part of the project that I was involved in, and which Nicola mentioned earlier, this research shows that the narrow way in which the scope of what are negotiable issues and appropriate subjects for union representation in the workplace, and the narrow way in which it is defined in the legislative framework that in the UK sits alongside voluntary industrial relations, actually has had the effect of constraining more expansive negotiations at the workplace level despite union activism, capacity building, and willingness of many workers to actually engage with management on these subjects. Obviously, these are just a few examples, but I cite them here because they illustrate that it is often law, especially this jurisdictional division of labor, if I may say, and artificial kind of historic fragmentation of otherwise interconnected issues that can stand in a way of reconceiving the relationship between labor and environment and the interests behind them, and addressing the interconnected manner in which both are exploited and endangered through productive activity. At the same time, laws, jurisdictions, and boundaries are porous and open to being redrawn. Fragmentation makes space for contestation. So fragmentation, misfits, and regulatory gaps contribute to problems, but they also provide a space for alternatives to emerge. And it's really the question for lawyers whether regulation can play a role in facilitating such alternative, more egalitarian, ecological, just, emancipatory logics and ways of organizing work and life. Examining and troubling that this articulation between labor and environmental regulatory regimes to better understand their intersecting effects for the realms of work, social reproduction, and ecology is the first step towards that end. And then imagining and exploring possibilities of more fluid, systemic ecological relations between these regulatory fields and spheres of life is the next. And in my view, some of the most promising avenues to that latter end are through engagement with feminist, post-human, and decolonial theories, including those ontologies of the social and legal that recognize and incorporate care and the non-human world as intrinsically valuable domains. And this work has already begun in law, and I cite here some people who've started to contribute to this project. And there are others in environmental law as well. The reason these theories are useful, I think, is because they suggest that subordination of care-centric values and separation of society and nature in how we organize economies and regulate work and life remain consequential to relations of exploitation, domination, anthropocentrism, and coloniality. And so they can be helpful in rethinking how we regulate work and livelihoods that meaningfully sustain diverse forms of life in different kinds of contexts. Ultimately, however, as critical and decolonial theorists and social cartographers urge us, transformative possibilities can be really gleaned from the people, communities, and other actors, both human and non-human, whose lived experience and material realities we should look to in order to gain ideas on how to better regulate labor and environmental nexus. And I want to end by talking a little bit about methods and how it is that we could go about researching this intersection of labor and environmental regulation, both the problems and possibilities. First, I want to suggest that regulatory mapping can help us better understand the divergence and overlaps. Some regulatory, may I take just 1 minute to complete? Some regulatory areas and tools that are good entry points here are, sorry, this is my own timer, are occupational health and safety, which has already been mentioned, industrial pollution, but we could also look at environmental impact assessment tools in extractive sectors, pesticides regulation in agriculture, infectious disease control in care sector. We can ask what are the key legal categories, environment, labor, and labor subjects, and how are they defined and understood across different regulatory contexts. Second, ethnographic and social cartographic methodologies can help us glean how people, communities, and various actors experience and understand the labor-environment nexus. Social cartographic and participatory mapping work with communities, for example, can generate alternative regulatory maps reflecting on how they experience, live, and feel the regulatory landscape and what they deem to be legal objects and subjects. And I'm currently involved in a project or developing a project with colleagues from the Federal University of Ouro Preto in Brazil. And we plan on using both sets of legal mapping and alternative mapping to understand how labor, environment, and care issues intersect in law and life in a couple of mining towns in Brazil and in Ontario, Canada. And these are just some ideas for making sense of the fragmentation and its consequences, but also seeking possibilities. And ultimately, conversations across disciplinary fields are a key to that endeavor. Thank you, and my apologies for going a little bit long.
Not at all, Anya. It was extremely thought-provoking, and we have a first attempt at a conversation with Margherita responding and commenting on your excellent presentation. Margherita, the floor is yours, and you have 5 minutes.
Thanks for the invitation, and thanks, Anya, for the really interesting presentation. So all I can do in 5 minutes is, of course, to do very little, but trying to make some connections with existing environmental scholarship and ask a few questions that you might want to pick up later or not, up to you. So first, let me say something about your ontological claims that you're making. That you do, drawing on Polanyi, for example, and that is the assertion that the ontological dichotomy between nature and society is in fact a modern invention and an historical cultural construct that law is helping to reproduce rather than something that is inevitable and given. And I think this is a key starting point because it is also very much shared by critical environmental law scholarship, not necessarily in relation to labor, but more in relation to environmental rights, also in a lot of discussions on the Anthropocene. So I think basically the two fields have or are attempting to deconstruct this dichotomy, and they could learn from each other's attempts at deconstruction a little bit. And it does follow then that if we are serious about reclaiming different ontologies, the question how best to do so becomes the key one. And so I really appreciated your note on research methods. And the fact that you're thinking about a mixture of more empirical research methods, such as ethnographic methods, and doctrinal, more traditional type of legal methods through regulatory mapping. Now, personally, I endorse very much empirical research because it helps getting up more of a bottom-up perspective and engage with lived experiences, and could also contribute to being almost an act of empowerment to recover silenced voices as well. And I think also more and more environmental law scholars are using empirical research, though much depends also on the cultures in which one is studying and working, and the extent to which socio-legal research is appreciated. But the question still is how best to do empirical research on this matter, especially if you're even interested in the more than human. Who should we talk to? Who should we engage? Which are the communities that and the participants that we're looking at? And I think that also something that we can potentially find useful would be research on the legal consciousness of workers. I don't know how familiar you are with the literature, but it could be useful. So there, how are communities orientation towards environmental and labor law? How is the law acted upon in everyday life? So outside official fora, outside courts, for example. And I think it would also be useful to reflect a little bit more on what to search for in the regulatory mapping that you're proposing, so in your more doctrinal type of work. Because if, let's say, the greening of labor law is becoming visible, the reverse, I think, is a little bit less so. So, okay, we have the Paris Agreement preamble, but there's not just climate change, of course, law in environmental law. So a lot of other environmental law fields, they won't have any mention on workers' rights. They don't have any mention on just transition as such. So what we'll be searching for, which concepts should we be searching for in environmental law to really foster this dialogue and discuss this nexus? And should we only look, and sorry if I have a lot of questions, but should we only look at the law and the policy, whether it's international or domestic, or shall we also look at maybe vernacular, customary law and those social norms and procedures that are not officially recognized, but they are very much used to manage relationship between people and their environment? And then finally, and then I conclude, I like when you stress that fragmentation makes space for contestations and enables alternatives to emerge. And the quick question that you're asking there is, how can this be facilitated at all by law? So also linking back to what was discussed in the first panel, shall we think about participatory process and the extent to which the law then enables certain procedural means to move towards that kind of pluralization, if you like, of perspectives, and how that will link to more distributive justice concerns that have preoccupied very much at least environmental justice scholars and potentially the just transition scholars. Thank you.
Thank you so much.
Thank you, Margherita. Anya, I'd be tempted to say you have 30 seconds to reply to these questions, but actually you have half an hour to think about them whilst the other presentations take place. And the next one is by Alexis Bougada, Occupational and Environmental Health, Meeting Points and Perspectives.
Merci. Merci beaucoup. Je vais m'exprimer en français. Je vais m'exprimer en français. Je remercie vivement les organisateurs de nous mettre en contact, chercheurs en droit de l'environnement et en droit du travail, à l'occasion de cet événement. Et surtout d'avoir prévu des personnes qualifiées pour traduire les propos du français à l'anglais. Et jusqu'à présent, j'ai pu profiter de leur service et je tiens vraiment à les remercier pour le travail qu'ils ont effectué jusqu'à présent. Et j'espère ne pas parler trop vite pour qu'ils puissent transcrire mes propos. De mon point de vue, la rencontre entre le droit du travail et le droit de l'environnement monte réellement en puissance. C'est quelque chose que l'on constate en France, mais même au-delà, mais en France actuellement, il y a un certain bouillonnement. Je ne veux pas trop insister parce que mes propos seront plus généraux, mais il n'empêche qu'il y a de nombreuses voix qui s'élèvent pour suggérer que le droit du travail et le droit de l'environnement ne devraient plus être cloisonnés. Pourquoi? Parce qu'ils font partie de la même question sociale. Et précisément, l'angle de ma communication porte sur un point d'achoppement commun, historique, originel, celui relatif à la santé. Santé au travail d'un côté, santé environnementale de l'autre côté. Les deux sont à bien des égards les deux faces d'une même pièce. Et cette évidence, paradoxalement, n'a pas empêché que ces deux droits évoluent finalement séparément, en silos. Textes différents, codes différents, peu de renvois d'une discipline vers l'autre. Rétrospectivement, cela peut surprendre. Alors, ayant peu de temps, mon propos va porter sur des généralités qui visent à poser les termes du débat. Et je ne serai pas particulièrement franco-français dans ma démonstration. Et la thèse est la suivante. Le point de rencontre entre ces deux droits concerne un objet commun, la gestion des risques, et un remède voisin, la prévention. Et la rencontre se fait à partir de ce qu'on appelle les risques mixtes ou les risques conjoints. C'est un concept précisément qui unit les deux droits. Alors, mes propos s'inspirent des travaux d'une chercheuse d'Aix-Marseille Université qui s'appelle Caroline Vanulz, qui doit certainement nous écouter aujourd'hui et qui il y a quelques temps de cela, publié une thèse sur l'interdépendance des risques professionnels et environnementaux et qui précisément poursuit le travail de chercheurs français sur ces risques mixtes, ces risques conjoints qui avaient été initiés par des universitaires comme Despax ou encore Alain Suppiot, qui est un travailliste bien évidemment, pour ne citer que quelques-uns. Et quant à moi, juste pour me présenter vraiment très, très brièvement, je me suis intéressé à la question environnementale sous l'angle des risques industriels au début des années 2000. C'est le point de départ. Lorsqu'il y a eu en France un terrible accident dans le sud de la France, à Toulouse, dans une entreprise qui s'appelait AZF, et il y a eu des morts, il y a eu beaucoup de dégâts aux alentours, en pleine ville, et tout ça a provoqué une réaction législative avec une loi en 2003 qui est venue renforcer les mécanismes de prévention dans le corpus de règles du droit du travail français en matière d'hygiène et de sécurité. Mais sous cet angle-là, sous l'angle des risques industriels, j'ai commencé à m'intéresser à la question environnementale avant même de déborder sur la question de l'écologie sociale, ce qui est une autre dimension du sujet. Alors pour aller vite, s'agissant des propos, je vais d'abord faire un constat. Puis après le constat, première étape, deuxième étape, rappeler les principes de prévention qui gouvernent dans les deux droits. Rappelez qu'en droit de la santé au travail, le droit de la santé au travail, avec l'aide du droit européen, promeut une approche globale de la prévention. Et une fois ces trois étapes franchies, je me hasarderai à tracer quelques perspectives pour l'avenir. Le constat, on peut aller très vite sur ce sujet et partir de l'actualité. La crise sanitaire que nous vivons modifie profondément notre perception du travail et de l'environnement, c'est une évidence. Et on voit qu'il y a bien un enchevêtrement des préoccupations, il y a bien une interdépendance entre la question environnementale et le travail. À la base, lorsque le virus s'est échappé, il y a bien une activité humaine productive et la qualité de vie en général, mais aussi l'ensemble des rapports de travail ont été bouleversés. Qu'on songe aux disparitions d'entreprises, au financement du chômage partiel, au protocole sanitaire, au recours massif au télétravail. C'est révolutionnaire. Et nous sommes invités à repenser les rapports sociaux, mais aussi les modes d'organisation de travail avec de nouvelles contraintes, mais avec une nouvelle sensibilité, car on prend tous conscience que d'autres grands risques peuvent se reproduire. Alors, à l'origine, le point de rencontre entre le travail et l'environnement, c'est ce qu'on a appelé les nuisances industrielles. Et ces nuisances industrielles ont donné lieu à des réactions pour éviter… une minute ? Ok, 5 minutes, ok. Pour précisément tenir compte des nuisances industrielles. Et l'OMS a adopté sa propre définition de la santé environnementale. Ce sont les aspects de santé humaine, y compris la qualité de vie, qui sont déterminés par des facteurs physiques, biologiques, sociaux et psychosociaux de notre environnement. Et donc, la définition est très large, et donc elle intègre aussi, techniquement parlant, la santé au travail. Deuxième étape, sur le plan des idées et des principes directeurs, droit du travail et droit de l'environnement se ressemblent. On a un principe d'information, de participation, de prévention, de vigilance et de responsabilité. Ce sont donc des textures qui font qu'on a deux droits qui sont vraiment voisins et qui pourtant ne se rencontrent pas toujours, sauf à partir de la notion de risque conjoint. Le risque conjoint, le risque mixte, c'est quoi? C'est lorsque précisément un accident du travail va générer un accident environnemental, lorsqu'il y a un événement environnemental qui va provoquer un risque industriel. On a vu par exemple le tsunami qui a provoqué la catastrophe de Fukushima. Le lien environnement-travail est ici évident. Et pour bien aborder la prévention, il faut davantage en droit du travail tenir compte des facteurs extérieurs que sont les canicules, les intempéries, les pollutions atmosphériques, le dérèglement climatique et le risque pandémique. Alors, troisième idée, la directive de 1991, directive 4 de santé au travail, pose des principes généraux de prévention. Pose des principes généraux de prévention qui sont semblables aux principes directeurs du droit d'environnement. Éviter les risques à la source, les évaluer, remplacer ce qui est dangereux par ce qui l'est moins, etc. Et la directive fait référence aux facteurs ambiants, tenir compte des facteurs ambiants. Elle ne fait pas référence à l'environnement. Bien que quand on s'amuse à traduire les termes, je crois qu'en italien, environnement, c'est ambiente, pour reprendre l'ouvrage de Paolo Tomasetti. Mais toutes les traductions dans les autres langues ne correspondent pas de la même manière. Donc, on gagnerait véritablement en efficacité si on était beaucoup plus explicite dans les techniques d'évaluation des risques en droit du travail, si on affichait clairement en droit européen et en droit interne que l'évaluation doit tenir compte des risques environnementaux externes et externes, internes et externes. Pour terminer, les perspectives, j'en vois trois. La première perspective, c'est qu'avec le développement de ce qu'on appelle l'écologie sociale, il ne faut pas perdre de vue qu'il faut conserver nos efforts aussi sur la prévention des risques professionnels et technologiques. La gestion des risques industriels majeurs doit rester une priorité. Et d'ailleurs, on peut même s'intéresser sur le fait que les principes de prévention en droit du travail, parce qu'ils sont globaux, pourraient davantage inspirer le droit de l'environnement. La deuxième perspective consisterait à dire qu'il faudrait peut-être imaginer à faire pénétrer des concepts du droit du travail dans le droit de l'environnement. Je me souviens, dans le rapport Agreement, nous avons fait des interviews et un représentant d'une organisation professionnelle avait dit « Faire attention avec le droit de l'environnement, il ne faudrait pas substituer, soi-disant, des produits plus doux pour l'environnement, mais qui soient plus agressifs pour les travailleurs. Il ne faudrait pas que ce qui est empêché de sortir par la cheminée de l'usine ressorte dans l'atelier. » Donc, la vigilance s'impose pour éviter les contradictions techniques. Et pour terminer, la proposition numéro 3 porte sur le droit de participation, sur le droit d'information, consultation des travailleurs au sein des institutions représentatives du personnel. Et à l'heure où je vous parle, en France, a lieu un débat très important sur une loi dite climat et résilience. Et une des propositions en discussion, mais qui est très avancée et qui devrait être acceptée, c'est que toutes les entreprises, pas uniquement les entreprises à risque, devraient informer et consulter les comités d'entreprise, ce qu'on appelle en France le CSE, le comité social et économique, sur l'impact environnemental de l'activité de l'entreprise. L'impact environnemental de l'activité de l'entreprise. Donc, pour toutes les entreprises, pas uniquement pour les entreprises classées à risque industriel. Ce qui veut dire que le périmètre du dialogue social peut changer grâce à la loi ici, et indiscutablement ce qu'on appelle le risque mixte ou conjoint qui est à l'origine de ces deux droits que sont le droit de la santé au travail et le droit de l'environnement seront sans doute encore mieux discutés par les représentants du personnel, et cela permettra à promouvoir une vision plus unitaire de la protection de la santé humaine au travail dans son environnement. Ainsi, il me semble que les rapports entre ces deux droits pourraient être plus fluides et naturels si les principes de prévention des deux côtés faisaient une référence plus explicite aux risques mixtes ou aux risques conjoints dont ils sont tous les deux issus. Je crois qu'il y a là un point sur lequel il faudrait davantage insister dans l'avenir pour réunir précisément ces deux droits. Je vous remercie de votre attention.
Thank you very much, Alexis. This was really excellent. Some common ground from where to start a dialogue, but the dialogue for now continues with Mathilde's comments to your presentation. Mathilde, you have 5 minutes, please. Thank you.
Sorry, is it okay?
Perfect.
Yes, I will continue in French, if it's
wonderful.
Possible.
Wonderful.
Thank you. Non, merci. Oui, je pense que les propos de mon collègue Alexis peuvent fournir différents types de réflexions, et j'en ai choisi une. De manière générale, ce qui est intéressant, c'est effectivement de constater qu'il y a un monde assez cloisonné entre le droit de l'environnement et le droit du travail. Ce sont les spécialistes de droit du travail qui s'intéressent à la protection de l'environnement, et en revanche, les spécialistes de droit de l'environnement s'intéressent assez peu à la manière dont le droit du travail peut protéger l'environnement. Alors, Pourquoi c'est intéressant? Parce que de manière plus précise, je pense qu'il y a ici un paradoxe important qui est d'avoir ou d'ignorer un peu trop souvent que finalement, la protection de l'environnement passe essentiellement par la protection de la santé. Le droit de l'environnement est essentiellement un droit tourné vers les intérêts humains, et parmi ces intérêts humains, ce sont les intérêts sanitaires. J'aimerais juste vous donner 3 exemples. Le premier exemple, il est tout simplement constitutionnel. Le droit français reconnaît dans la Charte de l'environnement de nature constitutionnelle un droit à vivre dans un environnement sain. Il ne s'agit pas d'un droit à vivre dans un environnement protégé pour sa biodiversité, mais protégé pour que l'homme puisse y vivre convenablement. Il rejoint ici assez largement la jurisprudence de la Cour européenne des droits de l'homme. La seconde impression est liée à l'historique du droit de l'environnement. Le droit de l'environnement prend ses racines dans un décret de Napoléon de 1810, qui est le décret qui protège le voisinage contre les nuisances environnementales. Il ne faut pas ignorer qu'au bout du compte, ce décret avait une seule intention, qui était de protéger la santé des ouvriers dans les entreprises. Pourquoi? Parce que les ouvriers étaient ceux qui travaillaient dans les entreprises et donc qui subissaient les risques environnementaux. Et en plus, les entreprises étant à l'époque dans le centre-ville, évidemment, ces ouvriers étaient ceux qui travaillaient aux alentours des usines. Donc, pour continuer à développer l'industrie, nous sommes au début du 19e siècle, il va falloir protéger les personnes qui travaillent dans l'industrie. Le troisième exemple, et alors l'exemple que je viens de vous donner est encore contemporain, il a encore 2 siècles et il persiste. Et le troisième exemple que j'aimerais vous donner pour aller dans le sens des propos de mon collègue, c'est la théorie qui est la théorie du trouble anormal de voisinage, qui est une théorie qui est connue dans l'ensemble des droits. Le Code civil italien la reconnaît, les tort law la reconnaissent avec, je crois, le tort of nuisance, public of nuisance. Elle signifie quoi? Qu'aujourd'hui encore, et depuis 1844, il est possible de demander à certaines entreprises de faire cesser les nuisances qu'elles causent dans le voisinage. Il s'agit pour les spécialistes de droit de l'environnement de la théorie la plus importante en termes d'action en justice pour faire cesser les nuisances environnementales. Or, il s'agit encore tout simplement, non pas de protéger l'environnement, mais de protéger les humains et la santé et incidemment l'environnement. Finalement, la protection de l'environnement pour ce qu'est l'environnement lui-même est extrêmement récente et si l'on regarde l'ensemble des lois qui protègent l'environnement, pour une grande part encore aujourd'hui, il s'agit de protéger l'environnement en protégeant avant tout la santé de l'homme et donc ici, bien évidemment, la santé également des salariés. Donc il me semble que le lien entre droit de l'environnement et droit de la santé et droit du travail devrait finalement être fait de manière encore plus poussée et plus naturelle. Je vous remercie.
Thank you very much, Mathilde. 3 very pertinent comments, extremely interesting. Our third presentation is from Consuelo Chacartegui from Pompeu Fabra, and the title of her presentation is The Collective Dimensions of Sustainability, Labor and Environmental Intersections. Cello, the floor is yours.
Thank you very much, Nicola, for your kindness. And thank you, of course, to the European Trade Union Institute for inviting me to this workshop. For me, it's a great responsibility to be here with you and these admired colleagues. Yeah, thank you, Kalina, for your organization as well and kindness. The aim of this presentation is to reflect on some collective dimensions of the intersections between labor and environment, but previously I'm going to make two preliminary considerations. One is that, in my opinion, the balance of the labor and environmental intersectionalities is positive. It's positive because this link involves an opportunity for achieving more ambitious goals in terms of human rights. Human rights, or the human right to environment, and the human rights at work. The Sustainable Development Goals of the United Nations provide this holistic framework, and I think that this reassures the human rights approach, involving a strategy of decommodification of labor and nature. The second previous premise is that the ecological and social intersectionalities, these eco-social links, deepen the protective function of labor law. And here there is an opportunity to strengthen the protective function of labor law through the subjective scope of our discipline of labor law. We have here two questions to stress. The central notion of worker is crucial for this protective purpose, and here we have the essential references of personal work relations, of the works of Professor Friedland and Professor Commentators that have treated this in an extensive way. What is new with this Green-Friendly approach? I think that the new thing is the strategies and actions that give us new methodologies, new ways to act in a bidirectional way. On one hand, workers taking benefits from environmental regulations, and on the other hand, environments take advantages on this protective function of labor law. What about these collective dimensions? That is the focus of my presentation. Crossing these intersectionalities, we face not only individual responsibilities, but also collective dimensions of the liability, of this conception of an integrated liability. I want to explain this reflection through three subdimensions. Framing ecological issues in the tasks, aims, and purposes of the trade unions. Secondly, embedding environmental matters in the right to collective bargaining. And third, facing the ecological matters in the form in which the companies are organized, particularly through cooperatives. The first dimension regards to trade unions' role. Here I think that we are in front of a chance for consolidating unions as social agents of intergenerational cohesion. The green sensitiveness of the social partners that has been shown at the European level and also in the national levels will involve consequences for workers, but also for the citizenship. Workers and citizens demand the commitment of trade unions in ecological issues, building up alliances with other entities, NGOs, civil society, for diminishing the negative effects of the transitions to a low carbon economy. And we have experiences here at the European Union level and of course on the national levels. For example, in the field of industrial restructuring and collective dismissals, this is very important, the role of unions in these transitions, favoring, for example, training of elderly workers, pushing negotiations and agreements, just transitions frameworks, just transitions agreement, collective agreements to tackle the challenges of the transitions at the workplaces. The second dimension connects with this, that is the dimension of collective bargaining. Collective bargaining arises as an adequate instrument to countervail the processes of domination of work and nature. There are positive features to take into account. The first is the power of transformation that the collective bargaining has. The evolution towards just transition requires transformative actions through regulatory binding instruments beyond social corporate responsibility. In the field of the green governance, the collective agreements ensure these binding regulations at the level of the sector and also the level of the companies. In the project agreement that Nicola has mentioned, that we are participating in this, Sergio Canalda and I from Pompeu Fabra University, we have detected new green-friendly provisions with impact in the environment in relation to the Spanish collective bargaining, for example, including clauses of sensitiveness through the environmental practices, including mechanisms of compliance of the ecological regulations, improvement of working conditions as reduction of working time, or providing measures of collective transport and mobility. Interesting is the new competencies and warranties for the representative bodies related with environmental issues, or even intersections with gender issues as a vectoral factor also, or a third dimension to take into account in all this scenario. Collective bargaining is also an instrument of intergenerational justice that involves this major concern with the public interest. And we could observe an irradiation of contents from top to bottom, from the European level, institutions and, for example, the trade unionist, the European Trade Union, through these, for example, joint opinions and joint declarations, could exercise an effect of irradiation to the national levels that take this experience as good experience to implement in collective agreements at these different member states. Another positive point is the adaptability to the territory. Collective bargaining has this virtuality of the adaptability at the circumstances of the just transition. And of course, the promotion of the environmental cohesions. Collective bargaining tends to a unitary or holistic perspective of rebalancing the power, and this contributes to ensure this cohesion. And finally, this connects with the third dimension, the dimension of what is the form of sustainable organization that we want. And here, I think that the best experience is the cooperativism. In Spain, we have the example of Mondragon. It's a clear example of this matching between environmental and labor concern. The cooperatives have this potentiality on embracing the ecological concerns of the communities. So workers owners tend to care about the local environment because they know their specific concerns of their communities. So this proximity of the workers to the territory is also it's a good channel through cooperatives. Cooperatives connect also strongly with the dimension of workers' participation. The absence of hierarchical social structures contributes to a more sustainable social organization. Bucking and Forman have important works on this. The workers appear as promoters of good practices in the great majority of sectors, in a vertical way, not only in a horizontal way, in every sector in which cooperatives are able to operate. This reflects sustainable practices not only in traditional sectors as extractive industry or chemical industry, but also in emerging sectors as construction, tourism, cement, etc. There are multiple examples in Spain. So the collective dimension involves a more equitable distribution of benefits, avoiding spoliation of resources and also exploitation of workers. Thank you very much.
Thank you very much, Cello. Impeccable timing, I should say. Chris, you have 5 minutes for your comments on Cello's presentation. Thank you.
Great, thank you, Nicola. So I want to start by thinking a little bit more about the collective aspects of labour law here. And just turning to the paper, I think I'd want to start by thinking about the types of analysis that we need to consider in this context. And I think there are three elements to this. First of all, there's a descriptive sense in which you can be looking at what there is on climate change, on the environment in existing collective agreements. You could be looking at what sort of dialogue currently exists on the environment and climate between the social partners. Or, you know, what sort of worker involvement capacity there is to have a voice on those issues. So that's very much a descriptive approach, looking at what there is out there already. You could also take a normative approach and argue for what you think there should be, and that obviously involves consideration of, you know, how effective and how good those current arrangements are. But I think perhaps what's also missing, importantly, is a third type of analysis, which is an empirical one, which is what evidence do we have empirically that this all works in practice for the environment and for the climate. I mean, Consuelo in her paper mentioned cooperatives, for example, and the, you know, the famous Mondragon Spanish Basque example. But you know, is there empirical evidence that shows that cooperative forms of worker organizations are better for the environment and better for the climate? I mean, I would perhaps point to French agricultural cooperatives and suggest that not all of those are particularly environmentally friendly, let alone climate friendly. So I think we need strong empirical data on that. Moving on from the type of analysis towards another aspect of collective labour law. It's interesting, we've heard a lot about the non-confrontational aspects of collective labour law, but we've heard very little about confrontational collective action. And I think it's interesting that the only type of climate strike that we've really come across is by school children, you know, led notably by Greta Thunberg and others. And I think it's in a way remarkable that, you know, that we haven't mentioned that already today. You know, there are good reasons, of course, why workers may not be able to strike around climate, and the law may be preventing them from doing that effectively. But equally, I would suggest that there's quite a big difference between a public interest matter like climate change and the environment and the kind of economic self-interest that tends to be associated with trade unions. The next point I want to move on to is a matter of tools, okay, or instruments that your discipline has available to you within labour law. There's a well-known saying that, you know, if your only tool is a hammer, then every problem looks like a nail. And I wonder if this is a problem that labour lawyers might fall into. Because, you know, there's a natural tendency to think, oh, well, what tools do we have available as labour lawyers? Oh, these collective tools are important ones. So we need to look at collective bargaining. We need to look at social partner dialogue. But I wonder if by doing that, you're missing actually a better opportunity for the trade union movement, which comes, I think, in two respects. One is actually to look at the separate field of sustainable finance, and particularly an emphasis on ESG, you know, environmental and social governance. And really, you know, trade unions and the pensions which their workers have a great opportunity at the moment to be really engaging with the heart of capitalist power, which is currently having a massive debate on ESG. You know, that's where the conversation currently is. I'm not sure it's really the capitalists are having a conversation about collective bargaining and where climate fits into that. You know, they are all talking about ESG. And I would have thought that trade unions could be using their collective power to get their pension funds to be pressuring on not only the E part on climate and environment, but more particularly on the S and the G and governance part, which is currently up for grabs. And I think that would be a different tool. It's a sustainable finance tool, but I think it's perhaps a more productive one than just focusing on collective agreements, which personally, I'm not sure empirically whether we've seen the evidence that will deliver. Have I got time, Nicola, for one more point? Okay, one more point. So, I mean, the other issue I was going to raise was to do with the just transition and the labour movement's nationalist versus internationalist focus. Because obviously the labour movement's always had that kind of strange mix of those two. It's both quite nationalist and yet it has an internationalism about it. And I think that's where there's a big connection with environmental law. We've talked about geographical scope in environmental law already. But it strikes me that, again, another tool that could be available and used would be something like a carbon border tax, because that not only deals with the issue of the environment and carbon leakage and offshoring, but that same offshoring is such a feature of globalization and lost jobs in many countries. And why is it, I mean, could you also say that if the unions are pushing for carbon border taxes, it will also lead to the protection of jobs and help towards a more just transition domestically? Of course, the danger with that is you could end up not producing a just transition internationally. And there are many fossil fuel reliant countries in the global south that could be disadvantaged and left behind by that. And I think that's a real problem. And I'll finish there. Thank you.
Thank you very much, Chris. Just when I thought that everything was going swimmingly for this dialogue, you pointed out some perhaps uncomfortable truths for us all. So may I suggest that our presenters take 3 minutes each to engage, perhaps not with all points, but to engage with some of the points that have been raised. I think it is clear to everyone that this is going to be an ongoing dialogue. That should take us to 1:15. There are a few questions that have come from the floor, and it would be also useful to spend some time engaging with those questions, I think. So perhaps, Anya, if you could take 3 minutes to engage with the
That's sure.
points that Margherita raised. Thank you.
Yeah, Margherita, thank you for engaging with the paper and my presentation. I just wanted to pick up on a couple of things that I make. I mean, all the points you made that were really useful and provocative for me. The question of which concepts in law, especially in environmental law, to look at when we do this kind of regulatory mapping and kind of mapping of overlaps and gaps. I'm in the project that I mentioned that would do a kind of empirical, that would do some empirical work in both Canada and Brazil. I will be working with environmental lawyers and urban planners, and labor lawyers as well. So the idea is that we together collectively, rather than try to figure this out from within our own disciplines, that we would really engage in interdisciplinary in that way and identify the appropriate concepts to look at from that perspective and from that place. And similarly, you ask also in relation kind of which concepts in law, you ask whether or not, we're looking at formal law only, or if that is what we should look at when we do this kind of regulatory mapping, or is a more plural conception of law and different, and more vernacular kind of rules and norms that are also necessary to consider. And certainly the kind of my approach would be to look at both, which is why the methodology that I'm proposing is dual. It's to kind of look at the law, the formal law, and to do that kind of legal or regulatory mapping, but also to engage social cartography and ethnographic work, and kind of generate alternative maps of how law is experienced and understood. And this is both kind of the effects of the formal law, but also the kind of community norms, the law of the shop floor, etc. So it would be both, and it would this kind of second level of alternative regulatory mapping would engage communities to do in that process of mapping, so that we learn from people who as they experience and understand law to be, both its effects and possibilities. And the last point that I wanted to make is you asked whether it's kind of procedural, or is it just procedural kind of legal norms that we could be thinking of as as possibly leading to some kind of a change. And because they facilitate participation, and we've now heard much about kind of procedural and kind of participatory mechanisms, but I think that's absolutely key. But I think if we take that question of ontology seriously and we rethink ontology, then that has implications not just for procedural law, but also for substantive, the way we see law substance as well. And so I think it is ultimately both of these, but also the tools. I need to pick up on what Chris said. I think we are quite married, even though I think a lot of people recognize that the boundaries are constituted and constructed, we're still quite married to them in a sense. And so it's only through kind of really taking a step back and reconsidering from the ground up, in a sense, what it means to have a more ecological approach to labor, but also environmental protection would be necessary. And I'll stop here. Thank you.
Thank you very much, Anya. Alexis, if you could engage with the points that Mathilde raised. And of course, in raising those excellent points, Mathilde, I think, further reinforced this message that you shared with us, that there is a common ground there that you identify in the interaction of health and safety and occupational and environmental health. But I was wondering whether perhaps that common ground, which I'm absolutely clear it exists, can really capture the broader question, the broader issue of the interaction between the two disciplines, whether it can be used as a testing ground to develop some common tools, a common language, some common principles and rationales, or whether it's perhaps exceptional in the overall relationship between the two disciplines. Thank you.
Merci d'avoir reformulé ces questions. Alors, toute la force des propos de Mathilde Boutonnet, c'était que précisément, elle les ancrait dans le droit positif, et notamment le droit positif français, à partir de l'ancienne théorie des troubles anormaux du voisinage, mais qui sont encore très, très utiles en droit français interne, qui sont très vivants. Et puis surtout, elle faisait référence à une norme dont nous disposons, nous en France, qui est une norme constitutionnelle depuis 2005, la charte de l'environnement, qui a une valeur constitutionnelle. Et on n'a pas encore en France, 2005 c'est presque hier en termes d'évolution juridique, on n'a pas encore pris conscience pleinement en France de la puissance évocatrice de cette augmentation des possibilités constitutionnelles. Et parmi les textes qu'a cité Mathilde, elle a cité l'article 1er, chacun a le droit de vivre dans un environnement équilibré et respectueux de la santé. Donc, on a la jonction, au regard des droits fondamentaux, en termes de santé au travail et santé environnementale et de santé publique aussi. Mais ce qu'on peut ajouter, c'est que l'article 2 précise que toute personne a le devoir de prendre part à la préservation et à l'amélioration de l'environnement. Toute personne. En termes de potentialité, ça n'exclut pas les travailleurs. Ça n'exclut pas les syndicats. Donc, les syndicats vont peut-être être amenés à modifier leur encodage historiquement ancré uniquement sur la défense des intérêts professionnels. Mais c'est là un regard un peu français, mais toujours est-il qu'on a cette norme fondamentale qui est tout à fait remarquable. Et puis, derrière cette norme fondamentale, on a une jurisprudence alors, qui a fluctué, mais qui a poussé très, très loin les exigences de responsabilité de l'employeur en inventant avec les affaires amiantes ce qu'on a appelé en France l'obligation de sécurité de résultat. Et avec l'obligation de sécurité de résultat, on était presque aux portes du principe de précaution où l'employeur devait répondre de tous les risques, même 10, 15, 20 ou 30 ans après, quand bien même le salarié n'est pas forcément malade. Et récemment, en avril 2019, la Cour de cassation française a admis que les salariés, même s'ils n'avaient pas eu de pathologie particulière, qui avaient été exposés à un risque majeur, pas que l'amiante, hein, ça peut être avoir travaillé dans des mines de charbon, pouvaient réclamer la réparation de leur préjudice d'anxiété. Vous voyez qu'avec ça, on n'est pas loin d'une forme de trouble anormal du voisinage, mais appliqué au droit du travail. Bien évidemment, c'est la question de la santé physique et mentale du travailleur qui est au cœur du dispositif. Peut-être que le droit français ici a des points extrêmement innovants pour réfléchir sur la jonction entre ces deux aspects. Voilà ce que je pouvais dire rapidement pour rebondir sur les remarques de Mathilde.
Thank you very much, Alexis. Thank you. Cello, are we holding this big hammer that makes us see everything around us as nails? I think it's one of the points that Chris has raised. Should we start thinking about areas of fruitful interaction that go beyond our comfort zone? Is, I think, one of the points he discussed. And we have, I think, throughout the day identified some areas of comfort for the two disciplines to engage constructively. But perhaps there's more out there beyond that comfort zone that may not be necessarily uncomfortable, may be conducive, although there are also some areas of discomfort probably.
It's true. Thank you very much to Chris for engaging my presentation with a lot of questions that are very important. And at the end of the day, I think that this shows that the current debates of labor law are through this path of the environmental sustainability and the just transitions. I have seen a very important point, for example, in the collective action, in mentioning the possibility of climate strikes and all these voices of workers that are necessary not only because it could be a form of expression of workers that is necessary in order to give voice to people, but also to integrate the whole society to these demonstrations, to this protest. It's important. It could be a nexus between the apparently two areas of knowledge that in the practice are a unique problem, a unique concern for the society. And for example, the tools or instruments, this is a very important question as well, because, for example, when Sergio Canalda and I have analyzed in the Spanish context the different models of the, for example, the representative bodies, we have seen two models. In the integration of the competencies, the environmental competencies in the guarantees and functions that the bodies have, or the creation of specific bodies for environmental questions, and disconnect also with the Alexis discourse in terms of health and safety is important. For, in my opinion, it is better the second model in order to face this question specifically, because, for example, we have suffered specific matters on it. For example, in the asbestos also regulation, we have a lot of persons that have died because lung cancer. Even the partners of these workers, the widows that clean the clothes of these workers, this is a very important problem. So I see in the discourse that is apparent of conflict, that these ideas shows us how we have the capacity to this adaptability that I mentioned before, with collective agreements, with the different expressions of the workers' voice, that I think that could be, if we study the ways in order to implement these voices, could be very successful at the end. Thank you.
Thank you very much, Cello. We have about 10 minutes left, and I was wondering if we could dedicate at least some of them to respond to some of the questions that we've received from the floor in respect of this second part of a panel of the conference. There's a number of interesting questions that arise, and I think they have a common trait. They're broadening the scope of the discussion beyond the terms of the dialogue that we've had so far. For instance, Willie, a colleague, Willie de Becker, says, should trade unions engage with a broader discussion that is linked to the ecocide debate? And I think the follow-up question is, how do we do that? And when we engage with these questions that offer a much more radical analysis of the perils of climate change and ecological transformation, does it have an influence on our debate? And Johanna Valdersen asks a question about a post-growth vision linked to a possible territory, I suspect, of further interaction, fruitful interaction, besides the health and safety territory for labor law and environmental law. And if I may quickly link this point to a link that Jeff Vogts has shared with us on the chat line about, so there's this is something that he and Ruan published a year and a half ago, when there was the climate strike that Chris mentioned, and they make a number of interesting points about how strike law gets in the way of a collective exercise and representation of those concerns, but also the importance of doing so quickly and in a timely fashion, because ecocide is around the corner. I think in their article they say we're only 11 years away, so now that's probably 9.5 years away from ecological Armageddon, from a non-reversible point. I think, I know that there are different views on this, but I think the closer we move to that, the more we need to think about more radical, non-linear even forms of engagement between these two disciplines. Perhaps I could ask all the speakers in our second panel, including our commentators, if they have some views that they would like to share on these questions.
Shall I jump in?
Yes,
Yeah,
yes.
If that's okay. Yeah, I mean, on the issue of economic growth, I mean, we started off today thinking about you know, what the aims of our two subjects are, environmental law and labor law, and at a very basic level, you know, they're about protecting the environment and about protecting workers. You know, that's often how they're conceived, and that raises the issue of protecting them from what. And in the case of workers, it could be protecting them from the unequal power relationship with capital. And with the environment, one might also say, well, it's about protecting the environment, not only from kind of humans, but from the capitalist system which humans have created. So, you know, capitalism seems to be something that actually, you know, the two forms of law and what they're seeking to protect people from is you know, that's what they have in common. And obviously growth is at the heart of capitalism as an economic system. And the question is, of course, for the environment, that's seen as almost impossible to get away from, you know, without associated environmental harm. You know, so a lot of people in the green movement would say, well, you can't decouple growth from environmental harm. It's just not possible. So you have to change the system. More technologically optimistic people say it is easy to decouple the two. And you can have economic growth and have the environment and the climate protected. But I think there is that definite tension there in environmental law. With labor law, is the same tension there? I mean, historically, one has typically seen the labor movement be pro-growth, and one's not aware of a similar tension, although I'm sure the labor lawyers here will tell me otherwise, which I think is, you know, it's an interesting question to ask, whether those similar debates have taken place in labor law in the way that they have in environmental law and environmental policy. I do have some thoughts on ecocide, but I'll let others come in at this stage.
Thank you very much. Thank you, Chris. Any other thoughts? Anya, yes.
Just wanted to jump in on this as well. I think, Chris, the conversations around kind of degrowth or post-growth or the problem with growth are less common in labor law scholarship, but they're not uncommon in labor studies. So if you look more generally at labor studies, there's definitely that current as well in those debates. And in fact, from my research and conversations with trade unionists in the UK, in the context of a previous project that I've done, I know that, you know, trade unions, and also from literature, I know that trade unions themselves are divided on this issue, but there's certainly trade unionists that also take on that position that we have to, that, you know, steady state economies or degrowth are an important, these are important goals to consider if we are really going to tackle the social kind of exploitation, but also environmental degradation that capitalism kind of engenders. So it's there is definitely that conversation, but it is quite fringe in the context, obviously, of trade unions, and it's more common in the UK, from my experience, in the public sector unions, rather than, of course, in energy in those unions that organize energy workers or those workers who are engaged in fossil fuel industries or in the private sector more generally. Thank you.
Thank you very much.
Can I jump in very quickly? Is that possible?
Yes, Margherita, please.
In terms of like just this discussion, if we look at, let's say, sustainability rather than necessarily sustainable law, rather than necessarily environmental law, and even if we look at environmental law, I'm not 100% sure, though, that the discourse on green growth and blue growth is not there. In fact, has been quite, I think, embedded in a lot of the sustainability discourse, at least in policy. And even if we think about environmental laws that are very ecocentric, such as nature conservation law, so not your climate law, not others, not industrial pollution, but those that are more ecocentric, like nature conservation, we still see that growth in terms of economic development is not completely forgotten. And in fact, the whole law plays on this trade-off between environmental protection and economic, primarily socioeconomic development, but primarily economic development. So I'm not totally in agreement that degrowth is so central in environmental law and sustainability really discourses than actually was proposed. Maybe in the scholarship, yes, but not necessarily in the legal and policy discourses.
There may be time for a final comment before I have to try my best to wrap up this incredibly rich workshop. Not even sure I could do it with a session. Is there anybody else who would like to share a thoughts on these important points? Cello, yes.
Very quickly, but with the reflection of the eco side, no, and the role of trade unions, I think that it could be a possibility to engage all the decent work agenda and the need of the last ratifications in terms of domestic work, etc. All the declaration of the principles of fundamental rights at work. I think that it could be connections here, because if we conceive the future of work fair, inclusive and secure, here could be some points of union to face this neologism of ecocide that has a lot of questions behind, and important questions. This is a very big debate.
Thank you, Cello. Thank you all. It's almost time to close, to bring this workshop to a close, and we've been at it for a few hours, and it's been really riveting. But I don't know if you share the impression that we've only started scratching on the surface of this relationship between our two disciplines, and you know, this is something that we've been trying to do, and Kalina has been trying to do more systematically since her arrival at ETUI for a number of years, and it's a complex exercise. And my impression is that it involves both a profound understanding of one's own discipline and also a profound understanding of the other discipline, but also a sense of respect for the fundamentals of each discipline in order to avoid a sense of land grab. And this is something that occasionally, whenever there are conversations between labor lawyers and experts from other disciplines with whom labor lawyers and labor law has to converse on a more or less systematic way, and you know, be it human rights law, contract law, tort law, competition law, there is always this fear that there can be attempts of overreaching. What we have tried to do today, I think, it's something that is much more interesting and conducive to a future dialogue that will take place. We have both identified the fundamentals of our own disciplines, which of course we all know very well, so we didn't have to spend too much time, but we have tried to identify both some areas of contestation and some areas of in which at least values and principles are shared and even mutually reinforcing. I think I have found some of the examples that were raised in this second panel extremely encouraging as a base, a starting point to take this dialogue further and ensure that it's mutually reinforcing. One point that I think this latter part of the conversation has clarified for me, and I think it also links to one of the first points that David Dory made in his presentation, which was the first one today, and how the law of just transitions has changed from this rather minimalist, narrow view to this broader view it has developed over the years. And it's a broader view in which labor law has to share the territory with a number of other disciplines and other interests, and in a way becomes almost more vulnerable to this land grab issue. But I was wondering whether this is partly linked to time, and as time goes by, the environmental clock ticks, and as the closer we get to that -1 doomsday, environmental doomsday clock, the more these issues become pressing. And I feel that the more our labor law principles, our hammer, as Chris defined it, becomes slightly dented. So by that, I mean that this may be the best time for us to engage in this dialogue without the pressure of the -1 scenario, whereby I fear that other priorities and other values would take over this discourse. It would have been better to start this dialogue 10 years ago, but today is better than tomorrow. And I think we've made a great start, and I'm very, very grateful to all of you for doing just that. I'm extremely grateful to Kalina for organizing this event with the help of Angelique and the other colleagues here at ATUI that she's mentioned. Very grateful to the translators for their outstanding work. And there will be more such events in the months to come, because this is of paramount importance for the labor movement and for us all. So thank you again, and see you all very soon. Thank you.